court in approximately 1 minute. We remind you, keep your microphones muted. The next voice you will hear will be the voice of Justice Gish. A good afternoon to everyone.
Good afternoon, ladies and gentlemen. This virtual session of the Appellate Division is now in session. As my first order of business, I'm going to call the calendar and I will confirm to you the times that have been allotted for your argument. Please state your appearance when I call your case. People versus Badia.
Good afternoon, Your Honors. My name is David Rankin from Beldock, Levine, and Hoffman for Mr. Badia.
And for the people.
Good afternoon, Your Honor. Susan Paulson on behalf of the respondent, City of New York, not on behalf of the people.
Thank you. The appellant will get 5 and 2 for rebuttal, 5 for the respondent. Feiner and Lavie versus Zohar. We only have a respondent, Mr. Monaco.
So, what is with this thing?
Mr. Monaco, state your appearance. You're on mute. You're still on mute.
What is wrong with this thing?
All right, Mr. Monaco, I see you. So I'll note that you're here. You have 3 minutes for argument.
Thank you, Your Honor. Finally.
All right. B. Rosetta B versus Michelle B. That's submitted. Wells Fargo versus XL Specialty Insurance.
Good afternoon, Your Honor. It's John Ellison from Reed Smith for appellants Wells Fargo and Superior Guarantee.
Thank you. The other appearances?
Good afternoon, Your Honor. For XL Specialty Insurance Company, Michael Chester from the law firm of Skarzinski, Merrick and Black.
The Lloyd Syndicate, Mr. Brennan. Seem to be having a lot of technical difficulties this afternoon. Hopefully it will improve. Mr. Brennan? I'm assuming he was here.
Your Honor, this is Mr. Chester. Mr. Brennan was on earlier.
All right, so what I'm going to do is I am going to indicate that the appellant has 6 and 2 for rebuttal. Mr. Chester for XL Specialty, you have 2. Lloyd Syndicate has 4. If either of you gentlemen have a phone number and email for Mr. Brennan, please tell him that we are waiting for him.
Yes, Your Honor.
People versus, thank you. People versus Eric Christopher.
Good afternoon, Your Honor. Simon Greenberg for appellant Eric Christopher.
Good afternoon, Your Honor. Franklin Gunther on behalf of the people.
Thank you. All right, the appellant has 4 and 1. The respondent has 4 minutes. City of New York versus Siemens.
Good afternoon, Your Honor. Michael Smikin on behalf of Clifford Weiner from the law firm of Caligula, appellant, and also respondent on the cross appeal.
Good afternoon, Your Honors. Jesse Townsend for respondent, cross appellant, City of New York.
All right, you each have 6 on your main arguments and 2 for rebuttal. Same on the cross appeal. Padilla versus Absolute Reality.
Good afternoon, Your Honor. This is Andrew Kay for appellant Sircone Exterior Restoration.
Good afternoon, Your Honor. Ross Massler for respondent, Absolute Realty.
Good afternoon, Your Honor. Deborah Summers for respondent, the Fiedler Companies.
All right, Mr. Kay, you have 6 and 2 for rebuttal. Mr. Masler, you have 2 minutes. And Ms. Summers, you have 4 minutes for argument. Leading Insurance versus Friedman.
Good afternoon, Your Honor. Stephen Reinhardt for Appellant Friedman LLP.
Good afternoon, Adrian Zendel for plaintiffs' respondents.
All right, the appellant has 5 and 2. The respondent has 5. People versus Brett Wheeler is submitted. People versus Domingo Ortiz is submitted. American Transit versus Espinal.
For the appellant, Mr. Espinal, Simon Landsberg, Tajia Law Firm.
Good afternoon, Your Honor. Ethan A. Rothschild for respondent, American Transit.
All right, the appellant has 4 and 1. The respondent has 4. Shire versus Shire.
Good afternoon, Your Honor. David Kiko of Pillsbury Winthrop Shaw Pittman for Catherine Shire, who is appellant and cross-respondent.
Good afternoon, Your Honor. James Kennedy of Kennedy Berg for respondent and cross-appellant, Xylaware.
All right, and the appellant has 5 and 2. And Mr. Kennedy, you have 5 minutes argument.
Your Honor, if I may, we are also cross-appellant. I wonder if I might get 1 minute of reply of additional.
You didn't ask for it, which is why you didn't get it.
Oh, fair enough.
But what I'm willing to do is I can split your 5 minutes to 4 and 1.
You know what? I'll take the 5. I appreciate Your Honor. Thank you. Thank you.
Okay. DeManiel versus DeManiel. You're on mute, Ms. Veit.
My apologies. Good afternoon, Your Honor. My name is Jackie Veet, and I'm representing the appellants.
Okay.
Good afternoon, Your Honor. Elkin Abramowitz for the respondent, Adelaide DeManil.
Good afternoon, Your Honor. Jeremy Barber on behalf of respondent George DeManil.
Good afternoon. Let me first indicate the times. Ms. Veet, you have 6 and 2 for rebuttal. Mr. Abramowitz, you have 4, and Mr. Barber, you have 2. In addition, I'm just going to indicate that about an hour ago, I received a letter application from Ms. Tendy to close the courtroom, and I'm going to be denying that request. In addition, she also asked for access for other attorneys to appear on the Microsoft Teams, and we don't generally do that. If you have other attorneys in your office that are interested in watching the argument, and certainly we encourage that, we are an open courthouse, meaning that we live stream. An attorney can see, as well as anybody from the public can see the arguments in their entirety. McCormick family versus Fidelity Brokerage.
Yes, good afternoon, Your Honor. Stuart Kagan on behalf of plaintiff, appellants, and cross-appeal respondents.
Good afternoon, Your Honor. Dan Tabak from Cohen and Gresser on behalf of respondent, Fidelity Brokerage Services.
Good afternoon, Gary Mennett for defendant respondent, Interactive Brokers.
All right, Mr. Kagan, you have 6 and 2 on rebuttal. Mr. Tabak, you have 3, and Mr. Mennett, you have 3.
Thank you.
Budwilowicz versus Mark Nichols Associates.
Yes, Your Honor, this is Robert Budwilowicz.
All right, sir, you have 3 minutes.
Thank you, Your Honor.
You're welcome. Board of Managers versus Healy, that's a submit. Casey versus White House Estates.
Good afternoon, Your Honor. Howard Kingsley for appellants, Rosenberg and Estes.
Good afternoon, Your Honor. Ronald Languedoc for the respondents, Catherine Casey et al.
All right, the appellants have 6 and 2, and the respondents have 6. In addition, Justice Singh has recused himself from hearing this case, and instead we have Judge Mazinet, who has been vouched in to be on our panel. Consequently, the case of Casey versus White House is going to be the first case that we hear on the calendar. And I believe Judge Mazinet is with us at this time. So thank you. And we can begin.
Great. Thank you very much, Your Honor. May it please the court, I am Howard Kingsley of Rosenberg and Estes, attorneys for the defendant appellants in this classic model type Roberts J51 type of rent overcharge, which has been has been certified as a class action by Justice Singh several years ago. There are two primary issues on our appeal. The first issue is whether Supreme Court erred in determining that the landlord committed fraud. And the second issue that I'd like to discuss today is whether, as a matter of law, the default formula should be applied. I'd like to add that the appeal from the dismissal of defendant appellants' affirmative defenses and denial of use and occupancy motion will rest on our papers on that and won't bring it up here. And I also want to make clear that we're not appealing from the determination that the 78 apartments are subject to rent stabilization, because the landlord has treated them as rent stabilized since 2011. In connection with that treatment, after this court decided Roberts, there was an issue as to whether or not it would be applied retroactively. Gersten, in August of 2011, answered that question. Within several weeks, the landlord wrote a letter to all tenants advising them of the Roberts decision, advising the tenants that they would strictly adhere to that decision, that they hired an outside consultant to determine the rents, that they will look to determine the legal regulated rents, although the proper methodology had not yet been determined.
Right, we didn't have a methodology until Regina was decided.
Correct.
Okay, but when you set about to figure out what the rents were by whatever formula you thought was appropriate, was your consultant or was your client relying on any records? What was your client relying on?
They were relying on the records that they have in terms of going back, and that's how they came up with the registrations. This was a good faith effort to try and calculate it, and with this expert, he has over 20 years of experience in dealing with J51 abatement cases and setting rents.
I guess what I'm really trying to get at, and I should just hit the nail on the head, is it's agreed in this case in terms of what the base state rent, or what the base state is for determining the rent, correct?
Correct, Your Honor.
Base state, the 4 years before the action was commenced. Are the records currently in existence regarding that base state?
Yes, Your Honor. As we stated in our reply, there are at least 48 apartments of the 78 where the base date is actually set forth in the record. And
so let's be clear. This is Justice Weber. I just want to be clear. We're talking about 2007, are we not?
Correct, Your Honor. The base date on October 14th, 2007.
Exactly. And so now you're stating that in the record that there's actual evidence as to what the base rents were in 2007, what the rents were in 2007?
Yes, Your Honor. On page 257 of the record, it shows the base state rent for apartment 2B, which is the only apartment that was discussed in the opposition brief.
And so what is that based on? Is that a lease agreement? What exactly is the basis for that information?
The basis of that information is the lease itself, which they admit that they have.
They meaning the tenant?
Yeah, the tenants admit. On that page in the record, that is a spreadsheet or summary that was prepared by opposing counsel to state what records they had.
So you're relying on the records of the tenants. Does the landlord have any records which would support the rent?
Yes, those were the landlord's records that was put forth in a summary prepared by the tenants. So those are the landlord's records. There are also, in going through the different summaries, where they say, where the tenants' attorneys say that what the certain deficiencies are or are not. So for instance, one of the apartments that they mentioned in this motion for summary judgment, 12H, it specifically says that they have the apartment, they have the lease for that apartment. And with the lease, we would show the amount of rent on the base state. And I'm talking about
I just want to stop you for 1 minute, because I know there's kind of a collateral issue floating around here about preferential rents. Do the leases show what the landlord claims the rent stabilized rent is and the preferential rent that the landlord is claiming?
Your Honor, the issue is whether or not what the actual rent charged was at that time.
But that wasn't the question.
Yeah, I think we're kind of trying to all get to the same thing here. Are there records to indicate on the base date what the tenant actually paid?
Yes, Your Honor.
And that may or may not be the lease rent?
That is the lease rent.
So in other words, the lease set forth, because I know the landlord has a claim about preferential rent. I express no opinion about that right now, but I just want to know if that number is readily ascertainable from the landlord's records.
Yes, Your Honor. Just for an example, on page 257 of the record, which is a summary of documents provided by defendants, which was prepared by the tenants council for apartment 1D, it shows from 12/1/2006 to 11/30/2007, which would of course cover the base date. It shows that the rent was $2,200.
And that was what was paid and what was collected?
Yes.
Okay. You believe it or not, your time is actually up because these are complicated issues, honestly, even after Regina. But I'll let you wrap up and then we'll hear from Mr. Languedoc.
Great, thank you, Your Honor. The motion is based upon the wrong standards. Both in fraud, there can't be any willfulness. We are not aware of one case where the landlord has notified the tenants immediately after Gersten and has been found to have committed fraud. The other argument is that the default.
You may be wrong in the rents, though. You may.
What we're saying is
your calculation of the rents may be incorrect, though.
Right, but we still have to go back. It hasn't been determined as a matter of law on summary judgment. The case would have to go back for that for each of the apartments.
Why couldn't we determine it now under Regina? What do we have to do that for?
We can, but the plaintiffs haven't established what was not for those times. So we have certain records, but it is not crystal clear for all the apartments whether or not we have all the documents here, because there are 17,000 pages of documents that were produced that are not in this record.
Okay.
They were produced while the motion was pending.
Okay, thank you. All right, Mr. Languedoc, go ahead.
Okay, excuse me, thank you. Your Honors, the court, first of all, I would like to say that this is hardly a garden variety or clean Roberts case. In this case, shortly after matter was certified as a class action in 2012, the plaintiffs served discovery demands, fairly limited discovery demands actually, upon the defendants. And in December of 2005, which was nearly 3 years later, after 2 court orders, having only received a small amount of documents, we filed the motion for summary judgment, seeking that the rents be calculated pursuant to the default formula. At that point, counsel for the appellant requested, and we agreed, to give them another bite at the apple to submit additional documents And so the matter was adjourned for a prolonged period of time for them to turn over those documents. And then upon our analysis of those additional documents, which we presented in our reply, we showed that in not one case, by then we had determined that there were 78 apartments involved, that not in one of those cases were there sufficient rental history records to determine the legal regulated rents.
But your adversary claims that it's the actual records that you turned over from your tenants, or at least one tenant that he cited, that lease agreement shows what the rent was, and what the paid rent was. So that's what I'm not understanding.
That's not quite correct, Your Honor. What happened was we did not turn over records. We provided the court below with a detailed analysis of the records that were turned over to us by the defendants.
So
for the purpose of, yes.
I'm sorry. No, you can finish your answer.
Just
for
the
Judge
purpose
Weber,
of
and then
showing. Okay, thank you so much. We provided that analysis for the purpose of showing that there was not a sufficient rental history record for any of the apartments to establish the legal regulated rent.
So here's my question, and I know this is like shifting sands. It is for me too in rent stabilization. But while this case was ongoing, say in 2012 and thereafter, actually after Gersten, and we at the Appellate Division were really kind of struggling with what the formula would be for rent, as was the DHCR. I think one of the prevalent ways of figuring out the rent was something that they call the build-up method, where you go and you look at the rental history and you start to add in whatever the allowances are and see where the rent brings you up. In other words, you put yourself back into the position you would have been had the apartments been appropriately registered and not removed from rent stabilization under Roberts. And so, and that's my understanding. That was how I decided cases. And then Regina comes along, and Regina seems to totally blow that formula out of the water. Is that true? Am I misreading Regina?
Well, I don't think you're necessarily misreading Regina, but I think that that's not all that Regina stands for. And I would also say that Regina is obviously a very important case in this context, but it has no applicability whereas here there is a lack of rental history records. And I may add, after years of giving
counsel, it seems to me that after Regina, the primary question is whether there is a colorable claim of fraud. And if so, then you can look to something other than the 4-year look back period. Isn't that what Regina said?
Well, that
And if you agree with that, then tell me what is the colorable claim of fraud here? How do you show that?
Okay, so there's two parts to my answer, if I may. The first part is that there is a colorable claim of fraud, and the court below correctly so found, based on the fact, number one, that there was no documentation sufficient to show that but for the J51, any of the 71 apartments was lawfully deregulated. Second, the second prong of the fraud, which correctly found by Justice Leibovitz, was this recalculation issue that was raised by my opposing counsel, whereby the so-called expert performed these outrageous calculations and purported to allege in many cases that the tenants had to pay more rent, or that upon renewal, their rents were going to be increased by drastically large amounts because of the recategorization as stabilized.
So I want to be clear that you are resting on the behavior post Regina and not the actions of the landlord pre-Regina, because am I right on that?
No, we're relying upon the both. We're saying that.
But doesn't Regina say, as my colleague Judge Gish was alluding to, under Regina, unless there is some indication that there was fraud, we are to abide by the 4-year look back period, a statute of limitations, as it were, and we can't go beyond that unless there is a colorable claim of fraud. There is, under Regina, there is no other exception, or have I read Regina wrong?
Yes, I think you have. This court even held on its own in Simpson that the default formula is applicable where there's not a clean rental history record, which is also the case here. You remember that Regina was 4 cases that were essentially consolidated by the Court of Appeals. In each one of those cases, they had crystal clear, pristine rental history records. That's not the case here.
That's not exactly true, because what happened, and it's consistent with deregulation under high luxury deregulation, is that you stop registering. There is no registration for years for the apartments, and that was part of the problem in figuring out how to put people back in the position that they would have otherwise been in, right?
That is right, but in this case, the landlord did not comply with the 2 orders of the court below to submit sufficient records to show that the rents were legally increased to more than $2,000.
So, but counsel, back to the question though, what would the indicia of fraud be based upon Regina? Again, are you claiming that it would be the fact that there is no crystal clear rental history or clean rental history? Does that amount to fraud?
Yes, that combined with the failure of the defendants to rebut or even attempt to rebut the factual analysis that we provided to the court below.
In terms of their experts' calculation, is that what you're arguing?
Yes, the experts' calculation. The only evidence we have is an affidavit dated April 20, 2015, long before the motion, which was just based on conclusory allegations. The defendants had every opportunity to go through each and every apartment in detail pursuant to their own records and explain how they believed that the rents were legitimate, and they did not. Instead, they provided nothing but a conclusory affidavit of the expert and a conclusory affidavit of one of the principals of the defendants. On the contrast, the plaintiffs submitted extensive analyses of the documents that were turned over to us.
Okay. All right, let's hear it. Mr. Kingsley, you have 2 minutes.
Thank you, Your Honor. First is to the issue of
Mr. Kingsley,
fraud.
I apologize. I don't think, perhaps my question was not clear. What I was trying to determine was whether or not you did in fact provide records as to, and whether you're in possession of records, and they were provided as to the base date of the base year of 2007, which was the basis for the calculation and for the ultimate registration. And you said yes, but now your adversary is suggesting that the answer is no. So I'm trying to, was the landlord in possession of these records?
Yes, Your Honor. What I think Mr. Langendrock is saying is that he wants all the rental records back to the last registration rent in order to reconstruct what the legal regulated rent should have been.
Counsel, let me interrupt you, because what this course wants is the rental records for 2007, which is the base date, so that we can determine what is appropriate. And according to the record here, they are not available. They were not forthcoming.
Your Honor, we provided the leases, as I stated on
You provided the leases for the 78 apartments in question. Is that what you're saying?
Your Honor, we have provided for them at least 60% and maybe more. The plaintiff tenants have conceded that many leases have been turned over. What they want is the rental history records, which are
I'm more concerned with what you can produce, because it is upon your records that this decision has to be made. So you're saying to me that there are at least a good 25 to 35 tenants' apartments that we don't have records for from 2007 in order to appropriately determine what the base date is from 2007.
Your Honor, we have a limited record here. After the motion
But
for summary.
this is what I'm trying to ascertain why. Aren't landlords supposed to keep records of their rent, their leases for a number of years?
Your Honor, yes, for a certain period of time. But
Okay,
there's
so
also,
we had a decision in 2009, Robert v. Tishman, and had at that moment, you said and you argued in your initial argument that your clients were phenomenally, within a week of Tishman, sent a letter to the tenants. Well, why did they not preserve the records?
Your Honor, there's been no claim that we haven't preserved records.
You're telling me that there are only 60%, you only have about 60% of the records from 2007 for these 78 tenants at issue. So you are conceding that you don't have 100% of the records that is required to make this analysis.
Your Honor, we are not conceding that. The records on the base date are in the record. There are records of rent. The tenants refer to 3 specific apartments out of the 78. And for each of these 3 specific apartments, the base date is there, as well as many other records that have been produced. The issue as to whether or not we had produced other records at this point in time is subject to further discovery. Discovery is not completed, and it was a plaintiff's burden to make a showing as a matter of law that there was fraud, and they cannot do that. It wasn't incumbent upon us to show what the base date rent was at that
By
period.
the time that the petitioners made their motion, I would imagine that there were multiple requests for this documentation. Am I right?
There were multiple requests, Your Honor.
Okay, so if they don't have them to produce for their motion, it's because they weren't provided.
Your Honor, they admit that we produced records for these apartments on the base date.
Okay.
Okay.
I'd just like to
One last statement I'll let you make, because we're way over time on this one. Although I'll give both of you, it's complicated. For me.
For all of us.
Yeah, for me. Right. Anything, a final salvo, Mr. Kingsley?
Yes, thank you very much. The purpose of requesting all the records back in time prior to the base date was for the sole purpose to try and recalculate the rents on the base date using the reconstruction method. That's the complaint. They're not saying that they don't have all the records for the base date rate. They haven't in any way disputed what I've said about these
Well, of course, I mean, of course, at the time they were asking for that discovery, that was the general consensus was that's how you calculate the rent on a Roberts overcharge.
But that's now changed, Your Honor. It's changed. Regina specifically rejected that. So it's what was
unless there's fraud.
Right, but they haven't established fraud. They didn't argue any fraud. It was raised sua sponte by the court below. And we respectfully request that we have not seen one case in this classic Roberts case where there's been a finding of fraud, where the tenants were notified of the rent stabilized status of the apartment.
That we understand. I mean, I understand that. I mean, that's your argument. Okay, thank you. We have a lot to consider.
All right, thank you very much.
People versus Badia.
Good afternoon, Your Honors. Can you hear me?
You can.
Oh, great. Thank you very much. My name is David Rankin for Mr.
Oh, wait,
Padilla.
but you know, wait, I have to wait 1 minute. I don't know what I'm doing. Judge Masonet, thank you very much.
Thank you. I'm trying to
participating in this
log
panel,
off, don't mind me.
And Justice Singh is with us. And now I'm going to restart your time on Badia. My apologies.
Great. Thank you very much, Your Honors. My name is David Rankin from Beldock, Levine, and Hoffman for Mr. Padilla. We come before Your Honors on a motion to unseal grand jury minutes. The issue before us is Mr. Padilla was tried 3 separate times, eventually acquitted, and we have an action in the Bronx Supreme Court. And
so is it Badia? Is it Badia or Badia?
Badia.
Badia. Okay. Yeah. So it's a very, very high burden, high standard to unseal grand jury proceedings. Grand jury proceedings are secret, and in order to unseal the proceedings and obtain the minutes of that proceeding, an extremely high burden. So my question, therefore, is, have you met that burden, and how have you met that burden? How have you shown that the unsealing would establish any type? How have you established any type of compelling or particularized need for the transcripts?
Thank you very much. So in order to, once there's an indictment, there is a presumption of probable cause. In order to defeat that presumption of probable cause for a malicious prosecution claim, a plaintiff must show that the indictment was procured by fraud, perjury, suppression of evidence, or other bad faith conduct. That's from Cologne v. City of New York from Court of Appeals, 1983. So that is our burden. We have to do that. We have a need to do that.
But you already have the transcripts of the police, the testimony of the police officers. You already have the transcripts and perhaps the testimony, well, at least the testimony of police officers, because I think those were the only witnesses who actually testified. There were three trials. So at least there were 3 trials. So you would have gotten the transcripts in each of those 3 instances. So what more is there?
The issue is, if there was a transcript which was produced to the defense attorney, that does not necessarily mean that transcript was either maintained after the trial or provided to plaintiff's civil counsel.
3 times? 3 times? So 3 times it wasn't provided? And I don't, and I'm not really clear that is actually, is there a presumption there that because counsel was provided, obviously counsel is going to be provided with the transcripts, that he or she does not turn them over to his client, or his client does not have access to it, or that the client doesn't have access to the attorney to now secure those transcripts?
Well, Your Honor, we don't know what was actually turned over. We don't know if it was the complete record of the grand jury minutes. And one of the issues is, in order to determine whether or not we can show that there was fraud, is whether or not there was a complete telling of the at the grand jury. That is another way that we can overcome the presumption of.
I'm sorry, Counselor. This is Judge Singh. Are you suggesting that what the police officers testified to in the grand jury, they perjured themselves? I mean, is that what you're suggesting?
Well, I mean, that is one of the ways that you can show and overcome the presumption of.
Okay, so what's the basis? What is the basis for that statement? That in fact you believe that there was perjury or something akin to that?
Well, I mean, on a very direct level, in this particular case, we have evidence to suggest that at least one of the officers claimed that a cell phone that did not belong to my client, which was involved in a drug conspiracy, did belong to my client. And that was testified to at the various trials. And one would believe that was also testified to.
But was the officer cross-examined on that issue?
At different points, yes.
So you have the cross-examination, you have those records. I still don't understand why you need the underlying grand jury minutes.
Because the underlying grand jury minutes, Your Honor, are the actual thing. We need to show that the grand jury proceeding itself was tainted. The issue is not whether or not.
I'm sorry. Why do you need to show? I do not understand. Why would you have to show that the underlying grand jury proceeding was tainted in order to sustain a cause of action for malicious prosecution?
Well, that is exactly what the case of Cologne stands for. We need to show that the actual grand jury proceeding itself was somehow done in a way that had bad faith, that there was not a full presentation. Otherwise, there is a presumption of probable cause. If we cannot show that the grand jury proceeding itself was in some way done inappropriately, that causes us to essentially not be able to present our malicious prosecution theory, because there is a presumption of probable cause, which of course is an element of malicious prosecution.
Mr. Rankin, if I may, what prevents you from deposing the officers?
We of course can depose the officers, but there's a couple points to that, if I may. Number one, it was 18 years ago and memories fade. And number two, in Napoli, which is one of the leading cases on obtaining grand jury minutes at 27 NY2D 238, the court specifically states that other sources of information which could get to this is beside the point. That's not the issue. We have the grand jury proceeding itself is essentially like a recording of, I mean, it is exactly a recording of what happened, right? And we need to show that the proceeding was in some way tainted. And so trying to attack that proceeding and show that it is tainted through mirrors or through recollections 18 years later is a far cry from the actual thing itself. That is what.
Well, that may well be, but I think what my colleague was referring to some extent is our decision in, I think it was Crespo, if I'm not mistaken, wherein you do have to make some showing that that you have attempted alternate avenues in obtaining the information, and that somehow those alternate avenues are somehow inadequate. So again, you could depose the police officers, but what I do not understand again is why you do not already have the transcripts of these officers. But again, there are alternate means in addition to again meeting this high standard of unsealing the grand jury minutes.
If I may just deal with Crespo specifically, because I think that is, of course, your court's last comment on the matter. Crespo is very different than this case. The application to unseal the grand jury minutes in Crespo was made by the defendants for the sole purpose of cross-examination. That is not what we have here. Here, we are attempting to show that the grand jury proceeding itself was in some way tainted or fraudulently procured.
But Counselor, I'm sorry to interrupt you, but don't you need a basis? Just saying that doesn't make it so, and it doesn't seem to me that it reaches the compelling and particularized need standard. Don't you need a good faith basis to even state that?
Well, we've certainly pled it. We believe I showed you a specific piece of testimony, which I believe is tainted, and he was acquitted. There was no showing. A jury didn't believe that he was associated with this.
So this is Judge Gish. I guess the problem that I'm having with your argument is that if you're correct, and any time somebody who is acquitted and sues for malicious prosecution, it would be an automatic turnover of the grand jury minutes, and that is not the law. That is not the law, as I understand it.
Well, it is common. My apologies, Your Honor.
No, go ahead.
It is commonplace to have the grand jury minutes turned over in a circumstance like this, and we've cited a number of Supreme Court cases doing this. The bar that we have when there is an indictment, essentially saying that we do not have access to grand jury minutes, puts such a high bar on bringing any type of malicious prosecution claim where there is an indictment. It makes it almost impossible. The grand jury proceeding itself in one of the federal courts says that it is the res itself. It is the act which is tainted. So we, of course, need to see the tainted act in order to prove.
But you have to have some basis. There has to be some basis to assert that it was tainted. The only thing you have argued is that there was a discrepancy or inconsistency in the testimony by one of the officers as to the cell phone. But as is pointed out by one of my colleagues, there was cross-examination of this issue. And again, the cross-examination was based in part on that attorney's possession of the grand jury minutes, so that he or she was able to present the officer with inconsistencies between his testimony in the grand jury and his testimony at trial. So again, I'm not understanding why, you know, the possession of the transcripts, the ability to depose, why these are not adequate avenues as opposed to the release of the grand jury minutes.
If I may just briefly on the issue of cross-examination at trial, because the idea that a defense attorney at trial, they are of course attempting to obtain an acquittal, right? There's no way a defense attorney is going to examine a police officer to determine whether or not they made a full and complete showing to a grand jury, right? That would be lunacy to be like, did you say this to the grand jury? Did you say that to the grand jury? Not having a full and complete showing to a grand jury is one of the avenues a plaintiff can use to overcome the presumption of probable cause that comes from an indictment. So having the actual grand jury minutes themselves could show this. And that's, you know, that's something that's necessary and not something that you would have any indication of from how somebody was cross-examined at trial.
Okay, let's hear from Ms. Paulson. You have to unmute yourself.
Yes, I'm sorry, Your Honor.
That's okay.
Susan Paulson on behalf of the city respondent. As Your Honors have observed, the essence of the appellant's argument is that his assertion of a state law malicious prosecution claim establishes his compelling and particularized need. He says that the legal standard articulated in Cologne alone is enough to demonstrate a compelling and particularized need. Certainly, that is not the case. As Your Honors has observed, it's an extremely high burden, and disclosure is the exception rather than the rule. And here, Your Honors, what the appellant tries to do is to start with the unsealing of the grand jury minutes. Instead, as Your Honors have observed, with the discovery that is available to him. He has not yet deposed the police officers or requested police records, and I don't know what is revealed in the minutes of his 3 criminal trials. One would imagine that there would be a motive to impeach the officer's credibility with any available evidence, even if it didn't bear upon necessarily the acquittal of the charges or attacking the grand jury indictment, anything that would impeach their credibility. One would imagine there would be a motive to explore at those criminal trials. He can't start with the unsealing of the grand jury minutes, and he has not articulated a compelling and particularized need. These grand jury minutes were available during these 3 trials, and he never asked to make a showing under seal, and has not done so here to establish what would be in those grand jury minutes. So it's entirely speculative.
Well, I'm assuming that there was a motion to inspect the grand jury minutes at some point in time, right? When the trial, when the case first began, there must have been a motion to inspect and dismiss, which I did not, I'm assuming that occurred. And so there was some inspection of the grand jury minutes to determine whether or not they were sufficient. But what I was also taken with by one of the statements your colleague, your adversary just stated, was that it is now somewhat commonplace for the grand jury minutes to be unsealed in these types of cases.
Your Honor, I'm not aware of that. My adversary has cited several Supreme Court cases in which that is the case, and certainly we saw Supreme Court cases in which that was not the case. These cases have not been tested on appeal, and even though
those cases were without the compelling need showing, or the courts found that there was a compelling need.
The courts found that there was a compelling need. None of those cases said that per se the assertion of a state malicious prosecution claim and the need to rebut the presumption of probable cause that the indictment creates per se satisfies the compelling and particularly needs. Those are
that was my understanding. That's what I thought, but I just wanted to know whether there were any other cases where, as he kind of alluded to, that standard had not been addressed or made.
None that I am aware of, Your Honor. Your Honors, I won't bother repeating, as Your Honor's questions seem to indicate an understanding of our arguments, which is that there has been no compelling or particularized showing here. He hasn't satisfied his burden, although he argues that the respondent speculates that the information might be included in the minutes from the pretrial hearings and 3 trials. It's not the respondent that has to show a compelling and particularized need for secrecy. It's the appellant who has to show the compelling and particularized need for disclosure. And that burden has not been satisfied here. And for those reasons, the decision of the Supreme Court should be affirmed.
Thank you. Mr. Rankin, you have rebuttal.
Yes, if I may. As your honors have heard, there are numerous courts that find that in order to rebut the presumption of probable cause, that shows a compelling and particularized need, which would lead to the balancing test from DiNapoli, which the court below erred, in our view, in finding that we did not show a compelling and particularized need, therefore did not move to the next step of the balancing of the various interests. It's our position that we did show that there was a compelling and particularized need in order to rebut the presumption. A blanket ruling stating that a malicious prosecution claim does not have access to the grand jury minutes, which are the thing itself which causes the presumption, creates a wall between a plaintiff seeking redress for being imprisoned without probable cause.
I'm not following that argument. I think that the assertion is that you have different avenues to pursue, and maybe at the end of the road, when discovery is near complete, and maybe at that point you make the application because you haven't been able to get certain records. Isn't that's really what the city is saying? I mean, you go through discovery, and then there's a determination ultimately whether or not you're entitled to those grand jury minutes.
I understand your honor's point. We rest on the phrase from DiNapoli, which says, I think clearly, that having collateralized ways of showing something is not the same as showing it itself, because we have to show that the grand jury proceeding itself was in some way.
I know, and counsel, you've said that a number of times. I think the point is you don't start from the top, that we have to unseal the grand jury minutes and then move down. You start from the bottom and say, this is what we've done, and we have not been able to meet our burden, or we cannot meet our burden without unsealing the grand jury minutes. So I think that's the way that you have to. I know that is what the cases say, and that would what the procedure would be.
Well, then we would request that your honors do have some type of limiting decision saying this application was premature, because I really would hesitate to erect a barrier between plaintiffs seeking redress for potentially years of incarceration and their ability to confront and rebut the presumption in a malicious prosecution. The presumption of probable cause, because that, quite frankly, would be dangerous for plaintiffs really all across the department.
Mr. Rankin, we understand your arguments, and honestly, we've given you way more time than we originally allotted. Thank you. Interesting
I
arguments.
appreciate it, your honors. Thank you.
Okay. Feiner and Lavie against Zohar.
Yes. Can you hear me, Your Honor?
We can.
Wonderful. We didn't get it right the first time. Richard Monaco, if it please the court, I'll be arguing on behalf of the respondent, and I will be brief. What the appellants here are really seeking is a per se ruling from this court invalidating non-solicitation clauses in attorney employment agreements.
Counselor, this is just a thing. How have you shown that Zohar, in this case, was involved in the solicitations of the clients?
Well, at a minimum, we have two affidavits and then a signed statement, which unfortunately is not notarized. And we have 2 grievances that were also filed where people are saying, they're actually saying that Jahan Osley, his office manager, was doing the soliciting.
Right, I understand. I saw the affidavits. I mean, so it's really Osley that they're sort of pointing the finger to. So the question is how do you connect Zohar to that? Through agency, through what? In your papers?
Well, thank you, Your Honor. That would be correct. That we would have to rely on that. Jahan Osley was the office manager for Gadi Zohar and Zohar Law. That is correct.
Did you make that argument in your papers, or are you just making it now?
I don't know if I actually articulated it the way Your Honor, Your Honor is smiling. So yeah, I don't know if I articulated it precisely in that manner, Your Honor.
Okay.
But we make it now. The Court of Appeals and the Appellate Division First Department have never gone so far as to draw a bright line rule that there is a strong or stark distinction between an agreement, any kind of agreement, employment agreement, whatever, that restricts the right of a lawyer to practice law after the termination of the relationship, and an agreement that seeks to prevent a former employee from soliciting, i.e. poaching clients.
Mr. Monaco, does that mean that you are otherwise conceding that part of the argument that to the extent the agreement contained that you can't practice law, you can non-compete, that's not enforceable?
Yes, Your Honor, absolutely.
Okay.
That is not enforceable. Fortunately, Your Honor, we have a severability provision, fortunately. Yes. May I answer questions from
You have another 30 seconds. Go ahead, please. Finish
I'd
up
like
your
to open it
argument.
up. Thank you, Your Honor. I'd like to open it up to questions from any of the other justices.
Any questions, colleagues?
Very good.
Thank you, Mr. Monaco.
Thank you. Thank you, Your Honor. Thank you.
Okay. Wells Fargo Bank against Lloyd Syndicate.
Good afternoon, Your Honors. It's John Ellison from Reed Smith on behalf of Wells Fargo and Specialty Guarantee. Your Honors are aware that this is an appeal from the dismissal of Wells Fargo as a party to the breach of contract action that has been brought concerning bankers' professional liability policies that were purchased in the 2008-2009 period by the predecessor entities to Wells and Superior, and that would be Wachovia Corporation, which was acquired by Wells, and Wachovia's captive insurance company, Beaumont, which has been renamed as Superior Guarantee. I will refer to those parties somewhat interchangeably because the documents are in the name of Wachovia and Beaumont, but Superior and Wells are the current successors and parties that exist today.
So your client indicates that the operative policy, the reinsurance policy, is the underwriter's reinsurance policy, right?
That is one of them. There are separate policies here, but that policy contains the most
the one
defendants.
that you're claiming under, or are you claiming under both of them?
We're claiming under both of them, but
all right, and so just to cut through what we're trying to find out here, do either of those reinsurance policies have a cut-through provision?
they do not, Your Honor.
Don't they need a cut-through provision in order for the insured on the general liability policy to be covered under the reinsurance?
I think the answer to that question is no, Your Honor, and
Why not?
I'll take you right to, well, let's go to the policy itself, which is in the record, starting at page 146. But the insuring agreement itself begins on the record page 148, and this is the underwriter's policy, to be clear. If you look at the first two paragraphs at the top of the first page on the certificate of insurance, it talks about the policy insuring involving an agreement between underwriters and the assureds, and it's a plural reference, not a singular. So assureds has to be more than one entity. Below that, in item A, are listed Beaumont and Wachovia as the reinsured and original assured. And if you move forward in the document to the actual terms of the policy,
Counselor, this is Judge Singh. I picked up on that language in your papers, but the question is this: doesn't the language have to be specific that there was an intention to be directly liable to the insured? Is the language that you cite, is it sufficiently specific for those purposes?
I think it's the beginning, Your Honor, and if I could just take you to a couple other provisions of the policy documents, I think I'll hopefully answer your question to your satisfaction. Because if you go to I'm now on the record at page 151, It again refers to underwriters and the assureds agree it as follows. And below that, it then talks about the assureds as are defined to mean the company and the directors and officers. And below that, in paragraph capital D, the term company is defined to mean the parent company and any subsidiary. The only entity that can qualify as a parent company in this relationship is Wachovia and now Wells Fargo. Both Superior and Beaumont were wholly owned subsidiaries of the parents Wachovia or Wells Fargo. So the only way you can apply meaning to any of these terms is to read it as applying to both of those entities as insureds under the reinsurance arrangement. And just to buttress that fact a little further, if you continue in the definition section, there is a definition of parent company. And parent company means the entity named in item A of the declarations, which takes us back to page 148 of the record. And the two entities, again, that are listed there are Wachovia and Beaumont. And the only one of those two entities that could qualify as a parent company is Wachovia, because I don't think there is any dispute among counsel or in the record that Beaumont is a wholly owned subsidiary of Wachovia, and now Superior is a wholly owned subsidiary of Wells Fargo. So for that reason, we think the contract documents themselves make clear that both parties were intended to have rights under them and therefore have the right to pursue claims for any failure to perform under that insurance arrangement. And just briefly beyond that, Your Honor, if you take a quick look at the transcript from the hearing, I think you will see that the trial court injected a couple of important points in its view into the decision-making process that were neither pled in the complaint, were neither raised in any of the briefs filed by the insurance companies, and used them as part, at least in part, as the basis for his ruling. And those are the discussion about the cut-through endorsement. You will not find the word cut-through provision in any of the briefing filed by any party. That first came up in the questions from the bench at the oral argument on the motions. Similarly, the judge seemed to
Counselor, isn't that a legal issue? I mean, whether or not there's a cut-through provision, what was inappropriate for the judge to reference the cut-through?
Well, first of all, it was not an argument raised by any defendant as to why the case should be dismissed against Wells, or the claims of Wells Fargo should be dismissed. But second, and more importantly, it presumes that that is the only way the contracts could afford Wells Fargo standing as a party to enforce them, when Wells Fargo, well, actually Wachovia, but now Wells Fargo, was named in multiple portions of these contract documents as an assured, in addition to the captive insurance company being an assured. So the concept that a cut-through endorsement is the sine qua non for the ability of a direct insured to sue a reinsurer is a faulty premise. So it's wrong as a matter of law under New York. And we cite cases that show that there are instances where the New York courts have recognized that direct insureds could have rights against reinsurers.
Well, is it, I mean, in a little bit, this is just sort of form over substance, the argument, because the question isn't whether there is a paragraph that says cut through, but the basic premise that I believe that the judge was talking about is the concept that there be a specific provision within the reinsurance contract that indicates that that the underlying insured is covered under the policy, and that's really it. And in fact, that's what you're trying to argue anyway. That is what you're trying to argue. You're saying you put together this piece and this piece and this piece, and you look at it and it says the assureds, and what they really mean is Wachovia, i.e. Wells Fargo. So I have to say, this argument about what you think the judge did or didn't do in talking about cut-throughs seems, at least to me, to be not that germane. That's just my opinion. It's not a question. Let's hear from your adversaries at this point. I think the first person up to argue is Mr. Chester. You have 2 minutes.
Your Honors, actually, I believe my colleague, Mr. Brennan, was prepared to go first.
That's fine. Okay, let's just have Lloyd's argue them. 4 minutes. Let's go.
Thank you, Your Honor. William Brennan on behalf of what's been called either the underwriters or the UK reinsurers. And I think that Your Honors have the right end of the stick here, that there is essentially a presumption that a reinsurance policy under New York law, there's a presumption that a reinsurance policy is only between the insurance company and the reinsurer, and that the underlying original assured doesn't have rights unless they're clearly established in clear language. And Mr. Ellison has done, I think, as good a job as he could of dancing through, pulling together different definitions and stringing them together and saying, look, if you look at it this way and squint real hard, maybe my client, Wells Fargo, has a direct right of action. But that's not clear at all. And in fact, just to take you through very quickly, I believe that Wells Fargo's interpretation of this policy is extremely aggressive and not reasonable at all. He took you to page.
Does it matter here that the insurance companies that are looking for the reinsurance under these policies are captives of the banks?
It does not in this case, Your Honor, because he is asking you to make new law under New York law to allow an underlying assured to sue a reinsurer directly. That would be novel under New York law. It hasn't been done before. When it has been done in other jurisdictions, it has been done because the insurance company is unavailable for some reason. Usually it's bankrupt. And then in the case of an unavailable insurer, they look to a course of dealing, look at the equities and all that sort of thing. None of that applies here. The insurance company superior is in this case. They are actively pursuing this claim. So Wells Fargo wants to add a completely redundant claim to superior guarantees. Superior has already claimed that it's paid.
Yeah, so honestly, dismissing Wells Fargo out of the case, what practical effect does it even have here?
That's a very good question, Your Honor. And I think the practical effect is that in my experience, the fewer parties and the fewer claims that exist in this case, the easier it will be to evaluate and settle or try. And so I just need to cut away everybody who doesn't have a real valid claim. That's just purely practical.
And it doesn't matter to you whether the insurance company pays Wells Fargo or not.
Well, no, it does.
It does.
It does because my client.
You're not going to pay unless Wells Fargo gets paid, right?
The reinsurance certificates indemnify the reinsurer only for payments made to Wells Fargo.
So it does matter. So Wells Fargo doesn't hurt or help being here, really. Maybe it helps. I don't know.
Well, it clutters up the docket and it just complicates matters. But the suggestion that there is an independent cause of action that Wells Fargo has against my clients, one, that's not good in this case. It makes it more difficult. And two, that's not a precedent that they would like to let go into the future.
Fair enough.
Just if we turn to, let me give you a very brief alternative reading of the reinsurance agreement here, the underwriter's reinsurance agreement.
You only have 3 seconds, so make it very brief.
Well, then in that case, the part of the reinsurance contract that Mr. Ellison is pointing to is an exhibit to the reinsurance contract. It's not a part of it. It's saying that's why the parent company is talking about it. If you look at record number 54, record page 54, that's where the parent company is. They're talking about the underlying insurance policy. Other than that, our arguments are raised in our brief, and I see the rest of my time, which doesn't exist.
Thank you. Thank you. Okay, Mr. Chester, go ahead.
Thank you, Your Honors, and may it please the court. My name is Michael Chester, and I represent XL Specialty Insurance Company. There is one additional reason why the judgment of Justice Ostrager should be affirmed, relevant only to XL Specialty, which is as follows. The XL policy attached to the plaintiff's amended complaint unambiguously states that no party except Superior Guarantee shall have any rights under the XL policy. And second, that in the event of any inconsistency between XL's policy and any underlying policy, the terms of XL's policy prevail. Therefore, Wells Fargo's argument that it is a direct insured under the document that it refers to as the underwriter's reinsurance policy is irrelevant for the purposes of determining XL's motions to dismiss. As I just articulated, first, the plain language of the policy specifically contradicts the plaintiff's argument. And second, the plaintiff's contention is an unreasonable and absurd reading of the policy, which is unsupportable as a matter of law. The XL policy here is dated May 20th, 2009, and the underwriter's reinsurance policy was not executed until the following year in January 2010. So what Wells Fargo is actually asking this court to find is that the terms of an agreed upon contract with XL are somehow modified 7 months after the fact by a separate contract it entered into with the UK underwriters, to which XL is not a party. Simply put, the plain and unambiguous terms of the XL policy control here. And accordingly, on that basis, XL requests that the judgment of Justice Ostrager be affirmed.
Thank you.
Thank you.
Right. Mr. Allison, 2 minutes.
Thank you, Your Honor. Just very quickly, on that last point, the fact that the court got into any weighing of what is the right document or what are the right contractual documents when there were a series of different agreements put before it is not something we submit that should have been resolved on a motion to dismiss. Those are fact questions as to what is the operative agreement. And the second the insurance companies raise the question of there is some other document that might be the right agreement, with all due respect to Judge Ostrager, Justice Ostrager, he should have passed on that issue so that it could have been developed in discovery for a determination as a factual matter as to what the result was. On the issue of New York law and reinsurance rights, we'd ask the court to take a look at the Globe reinsurance case, a New York Court of Appeals decision cited in our papers in 2017 that says even in the reinsurance contract, the party's intention is to be determined by the words used in the contract. And the words that I brought Your Honor's attention to in these contracts show that both entities were meant to be insureds with direct rights here. And last, I'll just ask the court to also take a brief look at the China Union Lines decision, which is a Second Circuit decision cited in our papers, also applying New York law that holds in part that a reinsurer may agree to be directly liable to the original assured, and we submit that's what happened here. So with those being my final points, we thank Your Honor for your attention, and we respectfully request that the Wells Fargo be reinstated as a party in this action by reversing the trial court's rulings on the motions.
Thank you. Thank you all.
Thank you. Thank you.
The next case is People versus Eric Christopher.
Good afternoon, Your Honor. Simon Greenberg, all Your Honors. Simon Greenberg for Appellant Eric Christopher. Mr. Christopher needed mental health and substance abuse treatment for his actions in this case, not punishment. Tragically, he was punished severely, a 3.5-year prison sentence and 2 years of post-release supervision. Although this court has limited authority to right this wrong based on the sentencing laws, Mr. Christopher respectfully requests that the court use the authority that it does have to reduce his PRS to 1.5 years. There are compelling reasons to reduce Mr. Christopher's sentence. He was law-abiding and gainfully employed for many years before his mental health and substance abuse problems worsened.
Counselor, this is Judge Singh. Can you address the issue of the appeals waiver?
Absolutely, Your Honor. The appeal waiver in this case was involuntary and therefore not enforceable. Mr. Christopher repeatedly expressed confusion about both the written document and the court's explanation of the waiver. And the only answers that, and that's, first of all, he never actually told the court that he understood, even after attempts by the court to remedy his confusion. But more problematically, the court's actual explanations that were in response to his statements of confusion incorrectly stated very clearly that only people who go to trial have a right to appeal. So there were errors throughout.
Well, counsel, I thought that his statement was that he was confused as to why the written waiver did not explicitly state he would serve 3.5 years incarceration. And then the judge went on to explain that to him, explain the contents of the waiver, and clarified the appellate rights versus the trial rights, as well as the plea waiver and the length of the sentence, the legality of this, his ability to challenge the legality of the sentence, etc. So I thought that she did actually, explain to him and took the steps to explain to him what exactly the waiver meant.
Your Honor, we respectfully disagree. What the court said to him twice during the appeal waiver allocution, and I can quote from the record, was, "Had you chosen to go to trial in this case and been convicted and found guilty, ordinarily you would have the right to challenge any mistakes that you felt were made during the course of the case, but by signing that written waiver, you're giving up that right." So that's a clearly.
But she did go on to explain the difference between the ramifications of the pleading guilty and trial rights versus, his rights in terms of the ability to appeal. She did talk about that, though.
She did talk about the right to appeal, but this is a case where there was so much confusion on the whole that the court cannot be confident, given his repeated statements of confusion and the multiple misstatements by the court, that he was able to glean the kernel of what may have been accurate from the court's statement. There was just thorough confusion throughout the proceeding. And he never told the court that he understood. After all of this, the court never actually confirmed that he understood.
I thought at one point, defendant confirmed he understood, and the court found his waiver to be knowing and voluntary. I'm looking at, it looks like page, I can't really tell the page. I just have a copy of it. But it says, do you understand? Defendant confirmed he understood, and the court found the waiver to be knowing and voluntary. But counsel, I had a question.
Yes, Your Honor.
In terms of the post-release supervision, what you are seeking is a reduction of the post-release supervision from 2 years to 1.5 years. Is that correct?
That's correct, Your Honor.
So when did he begin his post-release supervision? Was that this past March?
No, it was April of 2020.
April of 2020, and so
Correct,
it would be April of 2022 then that he would be finishing, and so you're asking, so it'd be 2021 that he would be finishing.
If Your Honor, I'm sorry, Your Honor, if the court were to reduce his sentence to 1.5 years, he would be done during the October of 2021, so October of this year.
As opposed to April of 2022.
Correct, Your Honor.
And
that would be the consequence, yes.
And so you talked about his mental health issues. You talked about, he was also recommended for CASAC while he was in incarceration in terms of his substance abuse. Isn't that necessary in terms of the post-release supervision to continue to ensure that he is receiving these services?
No, Your Honor. Mr. Christopher, as the court is aware from the record in our briefs, he has severe mental illness, and the services that he receives while he's on parole, this is outside the record, but generally speaking, when someone who has such severe illness as Mr. Christopher is released from prison, they get extensive discharge planning from the New York State Office of Mental Health, which is really what's responsible for helping him find a placement in like a residential treatment program. parole is really doing nothing but threatening to violate him for potential technical violations and things of that nature, which can really interfere with someone's attempts to obtain mental health. And so the parole is not really playing a role in helping him find that treatment. That's something that he went to obtain on his own while he was at Rikers Island. He received glowing remarks from the Cases organization, which said he was an ideal fit for alternatives to incarceration. Unfortunately, that didn't happen here. But he showed his own interest, independent of any compulsion that parole might impose on him, to go address his mental health and substance abuse problems. And just the threat here, really all that parole is providing is a threat to throw him back in prison. And that's not really what Mr. Christopher needs. What he needs is extensive mental health and substance abuse treatment, which he can get without the help of parole. That's something he gets from his discharge planning. So we don't think that. I'm sorry.
You're way over your time. I will hear from you on rebuttal. Let's hear from Mr. Gunther.
Good afternoon, Your Honors. Franklin Gunther on behalf of the people. Defendant knowingly, intelligently, and voluntarily waived his right to appeal this issue, and therefore this court should decline to review it.
Well, your adversary states that there were numerous instances of his confusion, which he made clear to the court, and also that the judge made numerous misstatements concerning the waiver.
Well, to address the confusion issue point first, as Your Honor noted, the confusion really was only pertaining to why the document that he was signing did not contain the agreed term of imprisonment and post-release supervision. It had nothing to do with his misunderstanding of his appellate rights. And as Your Honor also noted, the court made took multiple opportunities to explain both that the appellate rights were separate from the trial rights. And I would just note also that the defense brief suggests that the court said that these rights only apply when you go to trial. That really just happened once on page 8 of the record, leading into page 9. And immediately after that statement, the court did state, you do retain certain appellate rights. So for example, if any sentence that I impose on you would be an illegal sentence, or you were denied your constitutional speedy trial rights, or you didn't have the capacity to enter a plea or this agreement, you may still challenge those matters on appeal, even if you do not proceed to trial. And then the court asked if defendant understood those rights, and defendant confirmed that he did understand. So the issue of confusion was really related to a completely separate issue, not pertaining to whether he understood his appellate rights. And I think Your Honor had one other, well, I would just note that confusion was only related to that isolated issue. So, and I would also note that there really isn't any evidence that defendant didn't understand what was going on, or that he was somehow confused about what the written document said. The court, first of all, asked him if he was on substances or that would impair his ability to understand what was happening at the outset of the proceeding, and defendant confirmed that he understood what was going on. And to the extent that he was confused and stated that he needed time to consult with his attorney to understand the document that he was signing, the court gave defendant and the attorney the opportunity to review that, and then returned to confirming that defendant understood the rights that he was giving up. So in total, in the context of the entire proceeding, there's simply no evidence that defendant that his waiver was involuntary in some fashion. Turning to the actual sentence itself, we would note that actually it's not excessive, primarily because defendant was actually on parole for a violent felony when he committed this crime. And that term of post-release supervision was the same amount of time that he would be receiving in this case. And so there's simply no evidence that he's entitled to more leniency on that basis. And just the
But,
fact
but
that this,
Counselor, it does kind of strengthen the argument that, well, being on parole kind of increases the likelihood that he's going to get picked up for a parole violation, right? And
well,
that
if it's
maybe what he needs is mental health services. It's a pretty compelling argument.
I would just say that if there is some kind of technical violation, there's no indication that his actual violation of parole is the reason that he received this sentence. I would just note that it was the same amount of time, and that demonstrates that he's not entitled to more leniency if during that 2-year period for the last conviction he committed another crime. So we would just note that there's no indication that he's entitled to more leniency on that basis. And any trial judge who reviews the record for a technical violation, that doesn't necessarily mean that he's going to receive further incarceration just because he has violated the terms of his parole.
Okay, thank you.
Okay, thank you.
All right, 1 minute rebuttal. Go ahead.
Thank you, Your Honor. I would like to clarify that the misstatements by the court about that suggested that only people who go to trial have a right to appeal actually happened twice, not once. It happened on page 7. The court said, had you chosen to go to trial and been convicted and found guilty, ordinarily you would have the right to challenge on appeal any mistakes that you felt were made during the course of the case. By signing that written waiver, you're giving up that right. So that was the first time on page 7. The court said basically the exact same thing again on page 8 going into page 9. I think it's also a mistake to say that, oh, well, his confusion was isolated to was the sentence written on the paper. He expressed a concern that the DA was trying to trick him. This is someone who has a severe mental illness, and it shows a fundamental distrust in the whole process. He's very concerned that he's being treated fairly, and there really wasn't much of an effort by the court to clearly explain what he was giving. I mean, there was an effort, but there were significant mistakes in the court's efforts to make sure that he understood what he was giving up. And we would also say that the fact that he had the same PRS when he committed this offense, that just shows that what he needs is treatment. He didn't commit this offense because he lacked adequate supervision. It's because he lacked adequate treatment. And so the parole really had nothing to do with whether he was, going to go out and commit another offense. It's because he lacked adequate treatment. So we think that, as Justice Gist said, there is a compelling argument to be made that what Mr. Christopher really needs is compassion and treatment here, and not the threat of further punishment when he himself has demonstrated that he wants mental health treatment, substance abuse treatment, and to return to being law-abiding. He just needs to be provided with the resources to do that instead of just continuing to be punished. I
think you're out of time, Mr. Green.
Thank you, Your Honor.
Over time, and we understand your arguments, both of your arguments. Thank you both.
Thank you, Your Honor.
All right, the City of New York versus Siemens.
Good afternoon, Your Honors.
Afternoon. You can proceed.
Thank you, Your Honors. To set an appropriate context for this case, it's challenging to put 9 years of litigation into 6 minutes, but critically important.
You're not putting it into 6 minutes. We have your briefs and a pretty extensive record on appeal and prior appeals, so rest assured it's not 6 minutes which are going to decide this case.
Thank you, Your Honor. So the Supreme Court held, and is beyond reproach, that Mr. Weiner disclosed a pattern of repeated fraudulent activity by Siemens against the city and state of New York. It resulted in public contracts being awarded to Siemens in the amount of $260 million. Mr. Weiner was the relator of the deception involving both electrical licensing fraud and minority business enterprise fraud, and the city was unaware of the fraud prior to the relator's actions. All of that has been held to be uncontroverted, undisputed, and that is in the record at page 9 and 10 of the Supreme Court's decision. It is therefore also fact that without relators' disclosures and actions, the New York District Attorney would not have either the basis or the evidence to get Siemens to plead guilty essentially to criminal wrongdoing in the form of a deferred prosecution agreement and obtain
Counselor, this is Judge Singh. So there are essentially three different pots here from which you seek recovery, correct?
Correct, Your Honor, yes.
So how does that comport with Section 190, Pren 6 of the finance law, which clearly provides that you're entitled to seek a percentage of the recovery from this action? How do you reach to the other two pots?
Sure, Your Honor. So I think what's instructive here is a Ninth Circuit case, the Baraha case, which talks about how a single qui tam relator can obtain resolution from multiple different sources, including the initial action that involved a false claims violation.
Shouldn't we look to our statute first to make a determination on that issue?
Then, Your Honor, we can zoom right into the statute. At 195C, I'm going to read directly from the statute. It says, notwithstanding any other provision of law, whether or not the Attorney General or local government elects to supersede or intervene in a qui tam civil action, the Attorney General and such local government may elect to pursue any remedy available with respect to the criminal or civil prosecution of the presentation of false claims. And then it gives two examples of doing that. The provision, the statute then reads, if any such alternate civil remedy is pursued in another proceeding.
So in this case, did the city pursue alternative remedies?
Yes. Yes, Your Honor. Yes, Your Honor. And it did that through multiple different facets. It pursued.
And I'm not clear about that. Clearly, they intervened in this action. So what were the other alternative remedies they pursued under the other statute that you said?
Sure, Your Honor. So they also filed counterclaims and affirmative defenses in 3 civil lawsuits that mirrored the relator's allegations of false claims violations. Word for word, nearly identical, pursued counterclaims and filed for affirmative defenses, which resulted in the release of claims by Siemens in favor of the city. In addition, the New York District Attorney pursued multiple different criminal prosecutions, obtained guilty pleas, convictions, but more importantly, a deferred prosecution agreement and $10 million of what they called forfeiture in favor of the city of New York from Siemens. All of this, again, this is undisputed by the judge. All of these things flow directly from the disclosure of Mr. Weiner. Every single one of them. The court said that it's undisputed, uncontroverted in the record at page 9 and 10. But for those actions, but for his disclosures, but for all of his efforts in producing those results, you would not have a deferred prosecution agreement. You would not have criminal convictions. You would not have guilty pleas. You would not have defenses. You would not have counterclaims. And you wouldn't have a defense to a $140 million lawsuit that was filed by Siemens and that was just dismissed last month, according to our records. We have no idea what happened there. But a $140 million lawsuit is pursued by Siemens against the city. And then by stipulation, it's dismissed magically with nothing more discussed about it. And every single time in these lawsuits, the allegations mirror the false claims allegation violations that appeared in the qui tam complaint that was filed by the relator, Cliff Weiner. And that's in 195C, Your Honor. That's the exact language. And 7804 F2 has almost identical language. It specifically says, whether or not they elect to intervene and supersede, they can pursue alternate remedies. That doesn't mean you're entitled to only one remedy. There may be multiple remedies. And Your Honor, if you look at the case in the Fifth Circuit, Thornton, where they talked about that not only was it the cash value of the FCA violations that the relator was allowed to have his relator share attached to, it was also the non-cash value of releases. And in this case specifically, and Your Honor, this is the thing that probably troubled me most about what happened, is the language, the very language from the city in support of the settlement specifically says, and this is in the record, 847, paragraph 29 of the document there, and it says, moreover, the settlement of this case is paired with the settlement of a separate commercial litigation brought by defendants against the city related to the same contracts at issue in the NYFCA suit. That commercial litigation.
I understand all of that, but again, the plain reading of the statute talks about recovered in the action or in settlement of the action. So why, again, I'm not really clear as to why the plain language of the statute does not limit the recovery to that, the percentage of the recovery of the settlement of this case only.
And again, going back to cases like Thornton and Barajas, which talk about this issue, is that there could be multiple pockets, and I think it was Justice Singh that shared that there's these separate containers. There may be multiple remedies that the city or the state would otherwise be entitled to. They would be entitled to penalties for false claims violation. They would be entitled to essentially claim, we don't owe you anything under the contract because you breached by procuring the contract through fraud. Merely because the city decides to segment and seek those remedies in various different forms of actions, whether it's a criminal forfeiture through the New York DA's action, as affirmative defenses or counterclaims in other lawsuits, doesn't change the fact that all of this flowed directly from the relator's actions, which again, by the Supreme Court's own standard, was found to be uncontroverted. Without those actions, the city would not have those benefits available to them. And just because they go ahead and segment those actions does not mean that the relator is not entitled to a share of it. This all flows back to the policy considerations at issue here. The relator, the whistleblowers, put themselves at immense risk whenever they whistleblow, and especially for somebody like Siemens, and I'm not going to get into their history, but it's well documented inside this lawsuit. Siemens has quite a history when it comes to blacklisting individuals, when it comes to causing harm to their reputation, and more, and more. What you're essentially doing is saying, hey, the city, which essentially controls how much the relator share is going to get, can segment out just this little piece, settle this, and then no, everything else is outside and unconnected to the things that you do or have done with regard to your disclosure, with regard to the efforts of contacting the Queen's DA, the New York Inspector General.
We know the other parts, and you're way over your time, so you don't have to repeat that. But thank you, Mr. Smikin. Let's hear from Mr. Townsend.
Good afternoon, Your Honors. Jesse Townsend, Respondent, Cross Appellant, City of New York. Your Honors, Supreme Court's order setting the percentage of the settlement of this action that the relator should receive reversed with the amount reduced, but the order that determined that the relator was not entitled to the share of the pots, as Justice Singh referred to, should be affirmed. And the key questions to this appeal can all be answered of the New York State False Claims Act, the State Finance Law, Section 190, that Justice and Justice Weber have already cited to. The subsection 6A directs that the court is awarding a percentage of the proceeds of this action, meaning the key TAM action that the relator filed here.
But what about the 195C? Why wouldn't those provisions, alternative remedies, apply to the other tranches?
The 190 subsection 5C would apply only if it is a civil remedy pursued by either the city or the attorney general. So those two things by themselves knock out the deferred prosecution agreement. I know your honors are aware of this, but the Manhattan DA is not the city and it is not the attorney general. A criminal forfeiture is not a civil remedy. So that puts aside the deferred prosecution agreement right there. Then with regard to the settlement of the commercial actions, it would only apply if the city had elected to pursue this remedy in those actions as opposed to this key TAM action. And the key language that my opposing counsel did not read from section 195CA says, just a moment, your honors, says, the relator shall have the same rights in such proceedings as he or she would have had if the action had continued under this section. In other words, if for some reason this action was discontinued because perhaps the city deliberately dismissed it and instead pursued the action, the same remedy by filing its own civil enforcement action or litigating those counterclaims that Mr. Smikin referred to, that's when 190 subsection 5C would apply. That's not what happened here. The city intervened, superseded in this case. It withdrew its counterclaim. Mr. Smikin's not correct that there were counterclaims in all those contractual actions. The city did allege initially counterclaims sounding an FCA violations in one of those suits. It then withdrew it because it was pursuing this remedy in this case. That left just affirmative defenses of fraud that the city raised in its answers.
And the fraud, but isn't the fraud predicated on what the whistleblower reported?
The fraud was predicated on the deferred prosecution agreement and what Stevens admitted.
Well, but ultimately that comes from the whistleblower, no?
I don't know that it's established in the record, Your Honor, that the DA's office's investigation was predicated or would not be possible without the actions of the whistleblower. That's just not established in the record, I don't believe. Obviously, the DA's office put a lot of work into this investigation and obtained the forfeiture agreement, as well as the eventual criminal prosecutions and guilty pleas.
Well, is there anything that says that any successful prosecution or any successful lawsuit which flows from the information given by the whistleblower that he or she would have a portion of that pot of that settlement?
No, Justice Weber, nothing is that broad. The one subsection 5C would again apply only if the city had, or the AG, if the AG had been the superseding entity, if the Attorney General or city had deliberately pursued it a different way as opposed to.
What if the city shared the information? What if the city shared the information or the evidence with the district attorney's office or with the AG?
I still don't think that would apply to the statute, Your Honor. And as far as I know, that's not what happened here. But that's not covered by the statute.
That statute only refers to civil remedies, correct?
That's right. First, it only applies to civil remedies. So again, I think the deferred prosecution agreement would be out entirely. But even if it were some sort of civil action, it would really only be if this action had not continued. If instead the city was playing some sort of game where it was deliberately filing suit, bringing its own civil enforcement action, for example, as opposed to pursuing this action, this KTM action that the relator had filed. All the city did was allege affirmative defenses when sued by Siemens. But even if that in some sense, or at least even if that raised the possibility that settlement should be considered, just looking at the settlement itself, and compare this to the Thornton case, which Mr. Smykin cited. In Thornton, when settling an FCA claim, the defendants released in the FCA claim settlement agreement as part of the bargain certain claims they had against the government. That's not what happened here. What happened here is Siemens released its claims against the city in return for the city paying millions of dollars and agreeing to pay millions of dollars. But presumably, Counselor, at a discounted rate, right? There's no evidence of that, Your Honor. The settlement agreements, each settlement agreement was assigned a value to, on the one hand, the FCA claims, and on the other hand, the contractual claims. And they were both reviewed by the Comptroller's office and approved, as all settlements are. It's certainly the case that they reference each other, but there's no evidence that one reduced the other. That's just not present in this record. And so based on that, the comparison to Thornton just is apples to oranges. Then, Your Honors, if I may turn to the cross appeal.
You only have 5 seconds, so you'll have time on rebuttal for that. All right, let's hear from Mr. Smykin. You have 2 minutes, sir.
Your Honor, I'm going to focus purely on rebuttal of this issue then. Counsel indicated that there's nothing in the record that shows that but for the relator's disclosures or whistleblower, the city would have somehow found out about these frauds. The judge at the Supreme Court level specifically says, here, it is undisputed that the relator identified the fraud by Siemens Electrical, that the city was unaware of the fraud prior to the relator's actions, and that the case ultimately resulted in a $1.5 million settlement. So in addition, the record is completely clear that Mr. Weiner was reporting these violations to the Queens DA, to the New York Attorney General's office. The New York Inspector General's office had worked with the Department of Inspections as far back as 2008, which was 4 years before the prosecution. The prosecution relied almost specifically on the disclosures that were made by Mr. Weiner. In addition, counsel points to the agreements themselves. The agreements tell the whole story. It says we're releasing this in a pair with a settlement of a separate commercial litigation brought by the defendants. It's paragraph 29. In addition, there's preservation of certain rights for claims, and the two agreements actually cite to each other.
But as the counsel pointed out, though, the district attorney's office, the AG's office, et cetera, they're not the city. They're separate entities.
But again, for counsel to say that there's no evidence that it was the relator's action that resulted in the criminal investigation completely ignores the fact that as of 2008, this was being disclosed by Mr. Weiner, and there's been no evidence whatsoever from the city that says, hey, you're not the original source. We already knew about this. You're not the relator. There's one additional point that I want to make that's really critical, and counsel pointed this out when they said that the DPA is out of consideration. 195C, the state statute of finance law, specifically references any remedy available with respect to the criminal or civil prosecution of the presentation of false claims. It literally uses the word criminal prosecution within its own language.
But doesn't it also refer to civil remedies?
It does, Your Honor.
So hear me out for a second.
Sure.
So the forfeiture, is that a civil remedy?
Potentially a forfeiture could be considered a civil remedy. If they had prosecuted and restitution was assigned at the end of a criminal prosecution, then yes, an argument could be made this is purely criminal. But there's no indication at all that this forfeiture suddenly becomes outside of the scope of the relator share merely because it's somehow associated with the New York DA's office and that this forfeiture is turned into a criminal proceeding. But I will say that 195C specifically references criminal, and we can't render that phrase surplusage because essentially it doesn't give the full weight of what that statute is actually talking about. If they intended this only to apply to civil remedies, they would have said civil prosecution of the presentation of false claims. They specifically say with respect to the criminal or civil prosecution of the presentation of false claims. By adding criminal into the mix, the DPA is at play. And when we're talking about a forfeiture, which is essentially the resolution attached to a deferred prosecution agreement as opposed to restitution ordered after a criminal conviction, we believe that the court, as a matter of law, essentially decided, no, there's nothing for us to talk about here. And at minimum, there is.
But again, the DA's office is not the city. So I still don't. I'm still not understanding, because under the statute we're talking about the city, and again, the district attorney's offices are not the city; they're separate, and the monies would come from a separate pool, I guess.
Understood, Your Honor, but that's the same thing that would have happened in the Barajas case, where there was a settlement involving the Air Force between Northrop, the defendant in that case. And in that matter, the court said, yeah, that is an alternate civil remedy over and above the false claims violation, even though it's from a completely different branch of the government than was at issue under the circumstances. So there was a false claims violation case that was settled. The relator was paid his relator share. But then subsequent to that, there was a negotiation between the government during a quasi-criminal proceeding, a suspension disbarment from governmental contracts proceeding that resulted in a settlement, much like the DPA. And as a result of that, the Ninth Circuit held that that was considered an alternate remedy, not unlike the DPA at issue here.
Thank you. All right, let's hear Mr. Townsend. You have 2 minutes.
Thank you, Your Honor. Just very briefly on the DPA and the comparison to the Barajas case. This is where the statutory language makes a difference. In the Federal False Claims Act, the analogous provision refers to the government, meaning the entire United States government. In subsection 5C of section 190, it refers to the local government and the Attorney General. That is the difference between the two statutes. As Justice Weber's already said, the DA is not the city. It's also not the Attorney General's office. And while opposing counsel continues to cite that language that involves civil or criminal prosecution, he neglects the next sentence. And that's that next sentence that refers specifically to alternate civil remedies that would potentially give a relator access to a different pot of money. It's only civil remedies under that second sentence. The one part of the Supreme Court's order that we disagreed with and that we're seeking cross appeal on is the assignment of 20% of the settlement of this action to relator. That only, he would be entitled to such a high percentage only if he substantially contributed to the prosecution of this action. And the evidence is that he did not do so. Supreme Court itself.
Did he provide, was discovery provided? Was testimony given? Isn't that a little over the bare minimum?
I don't think so, Your Honor. To answer your direct question, the answer is yes. He did sit for a deposition. He did provide discovery. Those are part and parcel of bringing an action. He was a litigant. He chose to be a litigant. Therefore, the CPLR applied. And for that matter, Section 190's requirement that a qui tam relator provide all information to the state or the city when bringing such an action also applied. That was all just part of bringing the action and being the
Well, it actually was a little bit more than just bringing the action. Bringing the action is just filing a complaint. Right? That's what we referred to. So it was more. And I guess my question is, what was wrong with the trial judge's analysis about what the relator's contribution was? it seemed to be pretty thoughtful and gave good consideration to what the relator actually contributed.
Well, what's wrong with the Supreme Court's analysis is that on page 10 of the record, Supreme Court specifically said that he had not substantially contributed. That was Supreme Court's evaluation of the evidence. And then to make that decision and then at the same time award more than 15%.
Well, if he had been substantially contributed, theoretically, he could have gotten 25%. So she made an accounting for that, for the level of contribution.
And wherein you may not consider the fact that, the district attorney's office brought this action or the AG brought that action, et cetera. His information did lead to these various prosecutions. So it does, and actions. So it does seem that he did a little bit more than the bare minimum for the 15%.
I don't think that this court can consider his potential contribution to the criminal actions when evaluating what percentage of this action, how he contributed to the success of this action. And this court has already found that the criminal actions, including that deferred prosecution agreement, did not establish the elements of this action. That was still subject to the city to establish.
Well, my point was the city had absolutely no idea as to what was going on prior to his coming to the city and giving them this information. So and that's he did a little bit more in terms of depositions, as was pointed out, the discovery, et cetera. And as Justice Gish pointed out, the record does indicate that the judge did go through an analysis of, what he did and why then he would be entitled to a little bit to more than the 15%.
I'm not sure that was that
it wasn't a question.
No, just an observation. I think we understand your arguments. Thank you, gentlemen. Thank you both.
Thank you, Your Honors.
Padilla versus Absolute Realty.
Good afternoon. May it please the court, Your Honors. This is Andrew Kay from Gallo Vitucci Claw on behalf of Sircone Exterior Restoration Appellants. We're seeking reversal of the Supreme Court's denial of our motion for summary judgment on a number of issues. Pertaining to the first issue, the agreement that was entered into between my client, Sircone, and the general contractor, the Fiedler companies, clearly violates the GOL. It states in very clear language that Sircone is required to defend, indemnify, and hold harmless the Fiedler companies unless—
Counselor, if the case were to go to trial and the Fiedler companies were found not to be negligent, wouldn't the indemnification provision apply?
The indemnity provision would apply if they were found not to be negligent. However, I don't think they're under any reasonable interpretation.
That's my next question. Is there an issue of fact with respect to
that? Is there an issue? Percentages of fault, certainly, but I don't believe there's an issue of fact with regard to whether the Fiedler companies was actively negligent. This is a small job. This was a partial roof replacement that was subcontracted from the Fiedler companies to Sircone. The Fiedler companies was there every day. The Fiedler companies directed and controlled and supervised the work that was being done by Sircone, to the point where the Sircone foreman had the Fiedler company's telephone number and his cell phone if he had any issues. This court, as a matter of fact, in a different appeal that was brought by Absolute Realty against the Fiedler companies, awarded Absolute common law indemnity on the basis that the Fiedler companies had the authority and was to remedy the dangerous condition, was there every day, and failed to, in fact, do what it should have done.
Well, I think what we found is that that the supervisors exercised control and supervision over plaintiff's work. Is that a finding of negligence?
That particular decision, no, I don't believe that is a finding of negligence, but I think it demonstrates the level of supervision of control. And now we're here to answer the next question, which is, did the Fiedler companies exhibit such a level of supervision and control over this project that you can't differentiate between the two entities and who ultimately was responsible for the condition? And I think the record's clear that after this accident, it was the Fiedler companies that directed Absolute on the installation of the netting around the edge of the roof, And the
But
Fiedler
can we
companies,
consider that? Can we consider that information?
when it goes to control, you can consider it certainly when it goes to control. And if they're going to deny that they had control, then we can use that as evidence that yes, there was in fact that level of control. The plaintiff himself worked for 10 or 15 years for the supervisor of the Fiedler companies before he ultimately joined Sercone. These are not giant companies. This was not a giant construction job where the GC retains a super and says, go do your job. I'll check in every couple of days, or we'll have some meetings. This was the type of job where the GC was literally there every single day, overseeing the work, checking the work. Mr. Fiedler himself testified, when we get a job, this is a quote, and we subcontract it to, let's say, Sercone, the contract, if there is one between my client and myself, is proprietary to us. It has nothing to do with any of the subs. The subs are working for me, but it's my name, it's my reputation. Those are the words of the Fiedler company by their principal. So I think that in this very unusual situation, we have proof that the Fiedler companies was negligent. This isn't to say Sercone won't share, but in Rodriguez versus City of New York, the Court of Appeals made very clear one doesn't have to be free from negligence to prove that another party was in fact also negligent.
So the practical effect of what you're arguing is, if we were to agree with you, is the indemnification, the provision in the subcontract would be knocked out, essentially, correct?
Yes, that's exactly correct. And then one of the other issues that's raised on this appeal is the issue of a grave injury. And here, the plaintiff is not pleading a grave injury. The plaintiff has not alleged a grave injury. The plaintiff has not even submitted papers on the fact that the court.
But I'm confused by that, because I thought I read in the record that there's an allegation, at least by one of the experts, that he's completely incapable of working again, which is disputed by the defendants. Sounds like it's grave injury, no?
That he's incapable of working is different than being totally incapacitated because of a
appeals cases. Isn't that an element? You have to show.
My understanding of what the Court of Appeals has held is that an acquired head injury that prevents you from working, not any injury that prevents you from working. So in order for it to qualify as a grave injury, it has to be an injury to the head that renders you totally incapacitated, and that has been defined as.
So the plaintiff claims short-term, long-term memory loss. The neuropsychologist says cognitive deficits that are permanent, post-concussion syndrome, mild TBI, and then
mild.
Then the vocational rehab says he's unemployable.
Sure, the vocational rehab says he's unemployable, but he doesn't say it is because of his cognitive deficiencies.
I see. So that's
he says what the vocational rehab has done has taken the totality of the records, and if you look at what the vocational rehab expert has looked at, it's 38 medical records, 3 of which are related to cognitive complaints. The rest of it is his surgeries and the other injuries that he's alleging. And he's saying based upon all of that, he's not able to work. And I would also note the plaintiff hasn't treated for his limitations since 2016. When asked about what they were, he said, I sometimes forget where I put my wallet or my keys, and I repeat myself. He's traveled for a month at a time to Puerto Rico. He watches his infant granddaughter by himself.
This is Judge Gish, but those kinds of things go to the weight. That just is the kind of thing you put in front of a jury, isn't it? That doesn't mean that he's incapable of working because of head injuries.
Yes, and what I'm saying is that you look at the totality of the other evidence, which is all of these things that he's able to do, including the fact that he's never applied for SSDI, that they're not, the plaintiff isn't even alleging a grave injury. This is a dart that's been thrown at the board by the defendants in order to try to get some common law indemnity. The plaintiff isn't here today to argue for this.
We understand, but the issue is the same. I mean, you need a grave injury in order to bring the claims over. So Right.
And what I would say is that then forget the extrinsic stuff. Just look at the medicals. They haven't established. No neuropsychologist has said he can't work. None of the records, other than the chiropractor / life care planner / vocational rehab expert, based upon a 2017 examination of plaintiff, said he can't work, but he doesn't attribute that to his head injuries. He attributes it to the totality of the injuries.
We understand that argument. Okay, you'll have time on rebuttal. Let's hear from Ms. Summers.
Good afternoon, Your Honor. I wanted to focus primarily on the indemnification issue here, but there are a few other topics. So I don't know if the court has any questions for me on those other issues before I start talking about the indemnification. Okay. So I think in this case, the Dutton case is really important. The provision that was at issue in Dutton required indemnification for all liabilities arising out of the subcontractor's work, excluding only liability created by the indemnity's sole and exclusive negligence. And in that case, the court found that the provision did require indemnification, even where the GC was partially negligent, but they excluded that portion of liability that would be attributable to the GC's negligence. That's exactly the kind of situation we have here. In this case, the exclusion in our provision of liability resulting from Fiedler's sole negligence implies the inclusion of liabilities from Fiedler's partial negligence. Otherwise, the word sole would serve no purpose in that sentence.
Yeah, but that's the problem. It doesn't, somebody has some feedback on. Doesn't that violate the general obligations law? I mean, I agree, that's how you read it. But the question is, isn't that void under the general obligations law?
I don't think it is, Your Honor, because in Dutton, they looked at a similar situation where the reference in the provision was just to sole negligence, and they still said that allowed room for partial indemnification, which they were prepared to contemplate. In this case, Sir Cohn signed this agreement. The clear intent was for them to indemnify Fiedler within the bounds of the law as it existed at the time the agreement was signed. And the Dutton case tells us that even with the situation—
Well, actually, this agreement does not provide to the extent provided by law. If it did, it might be a different circumstance.
You're correct that it does not specify that. In the Dutton case, there was a specific clause that said to the extent permitted by law. Our position is that you get to the same result in this case based on the case law that we cited at page 11 of our brief, which says that the law that's in force at the time of the agreement is as much a part of the agreement as though it were expressed or referred to therein. So in the Dutton case, they expressly referred to it and expressly stated that it was to the extent permitted by law. Here, because that was the state of the law at the time of the agreement, that part is incorporated basically. And I don't think that any of the cases that talk about partial indemnification say that one must have both to the extent permitted by law and a clause talking about excluding.
So let's move on to a different issue. Was Fiedler negligent as a matter of law?
Well, I think as Justice Singh pointed out, or seemed to be suggesting, there is a question of fact. There has not been a finding of negligence with respect to Fiedler. And even if we all think it's highly likely that there may be a finding at the time of trial, we haven't had that finding yet. I also would disagree with counsel's characterization of Fiedler's role here. I think if we look at all the testimony from all of the witnesses, it's abundantly clear that Fiedler visited the site. They weren't there, they weren't omnipresent all day, every day. They visited the site daily to ensure that the work was being executed in accordance with their quality standards and the contract specifications. They weren't there to direct the means and methods of the work. Their visits focused on progress and quality control.
Didn't Fiedler have the authority to remedy lack of safety devices?
I believe Fiedler did have the authority, but I think the question is whether they exercised the authority.
Well, isn't the decision with respect to absolute, we said they exercised actual authority. That was the basis for the common law liability. I mean, that's already been established.
Right, but I don't think the question of whether they, I don't remember exactly what the language was that the court had used in the absolute decision.
Well, I'll get it for you if you want.
No,
it's as I said, honestly.
I thought it was that they had, I thought that it was that they had failed to exercise.
I'll read you the language. The record establishes that there were no protective devices on the roof, and that Fiedler supervisors who visited the site each day did not exercise their authority to order that situation be remedied.
Forgive me, Your Honor, the court knows better what it meant, but I read that to mean that they had the authority, but they didn't exercise the authority.
Right, to remedy the situation.
They had actual authority.
Yes, they could have, but didn't remedy the situation. Isn't that what we said?
I agree that that's what was said, but I think the key question is whether they exercised the authority. The court has found that they didn't, which is not the same as saying that they actually exercised supervision and control. They had the authority to do so, but they didn't.
Okay. All right. Your time has expired, so let's hear from Mr. Masler.
Yes, thank you, Your Honor. I have to apologize to you. Apparently, my camera is not working. I'm hoping you can hear me.
We can.
Okay, can I proceed just on the audio then?
You certainly may.
Okay, it was working earlier. I'm not sure what happened to it in the interim.
This is our new reality.
Yes, okay. Ross Masler for Respondent Absolute Realty. I'll be brief, Your Honors. Really, the only issue that the appellant raised that I want to discuss is the grave injury. First, I want to say I'm not quite sure I understand the appellant's argument with respect to saying the plaintiff didn't raise the issue of grave injury. Of course, he didn't. It's not relevant on plaintiff's case. It's only relevant on the issue of common law indemnity, and it's only something raised in the third-party action, which it was done here. So I'm not sure I understand that. Plaintiff
I think the argument is, Counselor, that the doctors really didn't connect his inability to work to his to the head injury.
Okay, and yes, that's I think that is his argument.
How do you respond to that?
Why he was saying plaintiff didn't raise it, although plaintiff certainly alleged a traumatic brain injury in his bill of particulars and his complaint and elsewhere, and has been treated and has been examined by doctors who have opined that plaintiff has sustained a traumatic brain injury. So a number of points I would make here. First, this court last year tempered the level of proof necessary for a grave injury within the meaning, or for a traumatic brain injury within the meaning of grave injury, saying in Goudan versus Pavlok contracting that plaintiff has to be unemployable due at least in part to the nature of the brain injuries that he sustained. And here we have, in opposition to a motion for summary judgment, we have a voc rehab specialist saying that he has examined the plaintiff, he has reviewed the medical records. He actually says at one point, and his experience working as a voc rehabilitation counselor with survivors of traumatic brain injury. He says as a result of those things, plaintiff is unemployable in any capacity. We would respectfully submit, Your Honor, is that given that this is the appellant's motion for summary judgment to dismiss this claim, that evidence is certainly sufficient to raise a question of fact on the issue, such that the lower court was correct in denying the motion for summary judgment. Unless the court has questions, we'll rest on our brief.
Thank you. Any questions, colleagues? Rebuttal, Mr. Kay?
Yeah, thank you, Your Honor. Regarding the contract issue and Dutton, I just would like to stress that there is no savings clause in this contract or this agreement, and that without a savings clause, any agreement that reads the way this one reads is void as against public policy. There's absolutely no question to that. As to the grave injury, I would submit that it is a very dangerous, slippery slope to allow a grave injury claim to proceed where a plaintiff voluntarily discontinues treatment 5 years before we're here in the appellate division, where neither the Dr. House Connect or Dr. Brown have indicated in their documents that he's unable to work because of an acquired hand injury. What we're relying on here is a 2017 examination by a chiropractor who says, based upon the few documents that have anything to do with the brain injury, that plaintiff has sustained a grave injury. We are opening up a giant, they could bankrupt the state insurance fund if this is the type of case that would proceed on a grave injury claim. I understand the plaintiff got hurt, but
we understand your argument, same argument you made in your direct argument. Okay, any further questions, colleagues? All right, thank you all.
Thank you, Your Honors.
Leading Insurance versus Friedman.
Yes, good afternoon, Your Honors. This is Stephen Reinhardt for the appellant Friedman LLP. Your Honors, this is an appeal from a denial of summary judgment by the trial court below. One thing I want to start out by saying is that our motion and this appeal do not bring before the court any issues of disputed fact. We did not ask the court below to address whether or not my client, the auditors, had properly conducted their audit. Rather, we focused on the rather extraordinary and unprecedented, in our view, theory of damages and causation posited by the plaintiff. This court and others in this state have recognized that theories of causation that are reliant on undue speculation and damages which are neither actual nor ascertainable are not recognized and are not recoverable in professional malpractice cases. And that's exactly what we had here. To summarize, Your Honors, Friedman had conducted an audit in 2012 of a statutory insurance company. Approximately a year later, it was discovered that the insurance company had insufficient reserves to account for incurred but not reported claims, known as IBNR. Shortly thereafter, after that disclosure, the Department of Financial Services penalized LIG, restricted their business, and LIG over a period of some 2-3 years basically changed its business structure, dramatically changed its personnel, its practices, pricing, underwriting, and other elements of its business.
Question, Counselor, this is Judge Singh. My question to you is there any evidence in the record that would support LIG's contention that had the deficits been recognized 9 months earlier, that it would have taken the same remedial measures to rectify it? Is there concrete evidence about that?
Justice Singh, there is no such evidence. In fact, there's no testimony by any employee or former employee or officer or director of LIG that they, in fact, would have taken the exact same measures had this deficit been detected the prior year. There is no such testimony, and there's no record evidence at all. It was simply an assumption.
What about the experts? That's
the experts assumed, for purposes of calculating damages, assumed that's what would have happened. So, for example, Mr. Hirschman, who calculated damages basically on a time travel method, if this had happened 9 months earlier, the company would have taken all these steps earlier, and it would have lost less money than it actually did lose because it was never profitable. Simply assumed the company would have done the same thing. But there is no actual record proof that that would have happened. And it's understandable why not, because if you look at the variables involved in what the company had to do to turn itself around, and this is Mr. Hirschman's report as well, he describes at length the policies that had to change to get the company to lose less money, including pricing, underwriting, training of brokers, claims processing, loss control, expenses, and personnel changes, including replacing almost the entire board of directors. All that plaintiff asserts, gee, same thing would have happened the year prior if the Department of Financial Services had come in and penalized us. And then they take the difference in the performance or losses of the company as they actually occurred, and the losses as they occurred from 2014 on, and that spread is $52 million, all of which they want Friedman to pay as what they call approximate result of a deficient audit. And our view is that under New York law, we don't recognize hypothetical and grossly speculative chains of causation or damages that are neither ascertainable nor actual to compensate victims of malpractice.
But Hirschman,
in fact,
I'm sorry, Counsel, this is Justice Weber. Hirschman did base his opinion on LIG's historical results, right? On the actual historical results, did he not? And so was that not sufficient?
It actually was kind of the reverse, in the sense that what happened was the damages expert looked at the 2014, 2015 results.
Right.
And then imagined that those could have occurred the prior year and just compared that to the actual results in the prior year and came up with this spread. So it was, I call it the time travel method, but it was imagining or assuming events occurred at a different time and under different circumstances, and measuring the purported difference between those two financial results.
We've recognized in Corcoran, for example, this claim of that there is a viable, or there can be a viable claim of lost time damages. No.
Well, I think I do disagree, Justice Singh, because in the Corcoran case, a couple things. One, the court very clearly said in the first couple of paragraphs, the issue in this case is the standing of the superintendent of insurance as liquidator of an insolvent insurance company to sue on behalf of the company. Two, the other issue is the standing of the superintendent of insurance to sue on behalf of the creditors of the insolvent insurance company. And so the opinion is all about standing and the expansive powers of the superintendent. The court was never asked to opine or pass, and did not opine, as to a professional malpractice claim against an auditing firm and the damages that might ensue in performing the audit of an insurance company. There is dicta that talks about the auditors did not disclose the true financial condition of the company, but it was never, the court was never called upon to decide, is that enough to give rise to a claim for, in essence, unlimited damages against an accounting firm based on the hypothetical or putative financial performance of the company in gross.
But the accounting firm would be liable. I mean, it's clear that the accounting firm would be liable for any damages caused by the negligence in failing to, I guess, uncover any deficiencies or anything of that nature.
Well, Justice Weber, you're right. And we've never argued that there can be no damages as a consequence of professional malpractice. But the claim as presented by this plaintiff, at least putting aside what's in the complaint, that's a different story, but as currently being presented by this plaintiff is only that their damages are based on this putative spread between their ongoing losses as they actually occurred and their ongoing losses as they might have occurred had they been penalized sooner by the Department of Financial Services. So that's the only theory that we had before us, and the one we argue is just not tenable under New York law.
All right, let's hear from Mr. Zendel.
Thank you, Your Honor. Can you hear me?
We can.
And you can see me. I was having microphone problems. Okay,
we can
great.
see you both.
Thank you. May it please the court, Adrian Zendel for the plaintiff respondents. Your Honor, first, the court correctly held, in our view, that Friedman failed to conclusively establish that its negligence was not a proximate cause of at least some of LIG's damages. And that holding is grounded in fundamental principles of proximate cause, and it's consistent with the accounting malpractice cases of this court and the cases we cite in our brief.
Let me ask you a question. Wouldn't you at least need a principal or somebody with authority from LIG to have testified or put in an affidavit indicating what they would have done had they been informed earlier? I mean, it's not enough for the expert to just speculate, because the expert has to have a basis for making that assumption.
Thank you, Your Honor. And the answer is no, we don't need that. And the expert does have a basis. And and that basis is, first, we can't forget this is a very strict regulatory environment that this audit took place in. And the fundamental purpose of the audit under the insurance law is to detect and report misstatements of that the insurer has, whether the insurer has misstated its financial condition. And here, there's expert testimony that Friedman failed to do that completely, and in fact, failed to detect and report a $30 million deficiency. And what we have is evidence which Friedman's argument asked the court to discount, in which we lay out in our brief on page 5 to 15 the facts which, on summary judgment, need to be taken as true, and giving LIG the benefit of every favorable inference on top of that. But anyway, we have, first of all, the expert testimony of Paul Braithwaite, our actuarial expert, who calculated the actual reserve deficiency that was in place at the time of Friedman's audit of about $30 million, and also the RBC ratio of the company, which was very close to a mandatory control level.
That would be proof of the malpractice. And for purposes of this motion, your adversary has already indicated that they are not disputing the issue of malpractice for this motion. So, okay, we accept that. You have an expert who established that it was a bad audit.
That's not the specific purpose of Mr. Braithwaite's testimony there. What he's saying, he calculated the RBC ratio. So it's a regulatory environment, and that's Insurance Law 1324 is the statute under which the DFS will intervene at certain levels. And so what he calculated was that they were very near a mandatory control level, which is essentially the same regulatory condition that they were in 9 months later when the DFS intervened then.
So Counselor, if DFS would have taken the same actions 9 months earlier, how did Friedman's alleged negligence, how was that approximate cause of the damages you're seeking? Because the same thing would have happened.
The causation question here is, no, the causation question is whether Friedman's negligent audit and failure to detect the true financial condition of the company concealed from the company its condition and prevented the company from taking corrective action sooner. And specifically, that had Friedman made the company aware of its financial condition at the time of the audit, it would have been able to take those. It would have, taken those remedial measures.
But that goes to the question Justice Gish just asked you. What's the evidence supporting that from the parent company, for example, these are the steps we would have taken 9 months earlier?
And the evidence, which is that they would have had to, because it's a strict regulatory environment, and so they would have.
Well, they wouldn't have necessarily had to. The consequence of not doing it is they would have gone out of business. I mean, they wouldn't. It's not a foregone conclusion that they would have or even could have taken the remedial measures that they ultimately did take.
Well, it would be a completely unreasonable inference to draw on summary judgment that they would have simply not done anything and let themselves go to liquidation.
Why would it be a reasonable inference to draw? Why would we draw such an inference when all you simply had to do was submit some type of affidavit from someone stating exactly how, what steps they would have taken or would not have taken? I'm not sure, I don't understand your argument in terms of, you know, a unreasonable inference, or why would even be drawing that such an inference.
Well, Your Honor, in our view, it is the only reasonable inference to draw because we have the evidence of that our experts rely on of what actually did occur only 9 months later, and the evidence of what they did in fact do is immediately take action to correct that problem, to cure the reserve deficiency first, but also to take remedial action, and that in fact improve their business, and that forms the foundation of Mr. Hirschman's damages calculation, in which he quantified a specific measurable amount of damages attributable to that delay, that 9 month delay. And in short, his testimony is that had Friedman reported and performed a proper audit, those changes that the company implemented in response to that reserve shock that it only learned about 9 months later would have been implemented 9 months earlier. And the fact of the DFS...
And it would have produced losses during that earlier 9 month time, right?
It produced additional losses. It doesn't change the fact that they still would have had to have taken remedial measures. I mean, if we're going to follow your argument through, they would have done exactly what they did 9 months later. It would have taken them exactly the same amount of time to otherwise remediate. They would have been under the impediment of the DFS during that time. They would have lost that money during that time. Why is that money different than the money that they lost 9 months later? No, it's not the loss of during that time, because it's additional losses they would not have incurred.
I don't understand. Well, my question is, I don't necessarily understand that. I'm asking you to explain that to me.
Right. Again, and it's the causation question is whether that the delay is that it caused them to not. In fact, it directly, as Hirschman states specifically, he says it directly impacted their ability to make those improvements sooner, and he calculates.
But sooner in time, but they wouldn't have. But why would we assume that they could make them faster?
He does. There's no. It's not faster. He doesn't calculate faster. He doesn't.
We couldn't assume that either.
Right.
All right.
His calculation.
All right. Honestly, I'll let you answer that question, but then we need to move on to.
Right. His calculation doesn't specifically. He testifies he doesn't assume any difference. He doesn't assume that the changes will be made any faster. So he's calculating based on the company's actual performance and applying those factors to the earlier time when those corrections should have been made.
Okay, thank you. All right, Mr. Reinhardt, 2 minutes.
Yes, just very, very briefly. I probably won't use the two. A couple of things. One, the actual deficiency itself in the reserves was cured within, I think, 2 days by an infusion of cash from the parent company. So that was never an issue, and there's no allegation of harm deriving from that deficiency itself. Secondly, the panel is correct that there was no testimony by affidavit or otherwise regarding the intentions of the company or its managers at the time in 2013, what they would have done, likely because in the complaint, as pleaded, never amended, LIG alleges that the DFS regulatory action was harmful and destructive to their business, which is diametrically opposed to their present position, which is that the DFS action was somehow what they required and needed to turn their business around. And it was Friedman's fault for not causing the DFS to come in and do just that 9 months earlier. Thank you, Your Honors.
Thank you. Thank you both. All right, Shire against Shire.
Your Honor, respectfully, on the Espinal matter.
I'm sorry. Did I?
I'm appellant on the American Transit versus Espinal matter.
You're correct. I made a mistake. Espinal comes next. Go ahead. So you are Mr. Landsberg. Go ahead.
Yes, Your Honor. Good afternoon. May it please the court. This is an appeal from the summary judgment motion from the DJ action related to the motor vehicle accident. And while both parties could agree that my opposition that was timely served should have been considered by the court when it made its premature decision 6 days before a return date, I've argued further on appeal 2 very important points. First, I've argued that summary judgment should have been denied to American Transit from the outset. And secondly, I'm respectfully asking the court to search the record on appeal.
Well, let me
grant
ask you a
summary
question, Mr. Landsberg. Let's start with your first argument, which is that the court made a mistake. It apparently decided the motion before it was returnable, said you didn't put in opposition papers, you apparently had. So why isn't the correct disposition of this simply to send it back down to the trial court and let them determine the motion not on default?
Oh, for 2 reasons. Number one, Your Honor, respectfully, it might be a bit fortuitous to go back to the judge who had a pre-written decision. It's only going to be granted again, and we'll be back here in another year.
Oh, I actually think that that's not an appropriate supposition.
Right,
Okay.
I think that's very disingenuous to the court. And so I don't believe that that would be a basis for searching, for our searching the record.
Well,
I don't even understand why you didn't make a motion to re-argue to the court when they made a mistake. The whole purpose of that is to let the court have an opportunity to correct the mistake rather than bringing something up to this court, which seems so ministerial to have, and appeals are expensive, rather than just doing it simply, rather than in the complicated route.
I understand, Your Honor, and I respect what the court said. My point at this juncture, though, is while this matter is still before this court now, the court below should still have denied the motion for summary judgment because American
Well,
Transit.
maybe it would have, maybe it wouldn't have. It didn't have a full record.
It did. It just stated they did.
No, honestly, if it said it decided it on default before the return date of the motion, it obviously did not consider your opposition. So I just don't understand why we would usurp what the trial court does. And that's what the trial court does. You know, sometimes we have ministerial mistakes, we clean them up and we move on. But it doesn't mean that the appellate courts start assuming primary jurisdiction over things.
I understand that, Your Honor, but before the court now is the appeal concerning the matter that American Transit did not meet their burden of proof in the first instance. And while we're here, I would like to make that argument to you.
But that's the whole point. Maybe you should not be here because maybe you should have made your motion to re-argue. And again, it is not like the motion court stated, well, they did not put in opposition papers. But even if they had, I've reviewed the record and the motion is granted or the motion is denied. So again, I recognize you're here, yes, but the question is, should you be here on such a ministerial issue? And again, the case law is pretty clear that these motions should be decided on the merits. And so again, the motion was made in Supreme Court. So why would Supreme Court then not have the opportunity to decide the motion?
The Supreme Court had the opportunity to decide the motion, and it
I'm
decided
sorry,
the motion.
I withdraw that question because we're kind of going around in circles.
We are.
Never withdrawn. Never mind.
All right, and actually you're out of time, so let's hear from the other side.
Thank you, Your Honor. May it please the court, Ethan A. Rothschild for Respondent, American Transit. As many of Your Honors have already stated, we simply believe that this case should be remanded for the lower court to consider appellant's opposition. This is a narrow.
Can I ask you a question though? So you can see the point. There was a mistake made below, right? So
Absolutely.
What are we doing up here? Why wasn't there at least even a stipulation between the two of you to vacate the default subject to the court's order and resubmit the motion? What are we doing in the appellate court on this?
Right, Your Honor. Although it's not in the record, I did discuss the situation with appellant, and I informed him that I would not stand in the way of any contact they tried to make to the court to remedy this situation. The reason we did not agree to a vacate here is because there's another aspect of this decision, which is the default motion that was granted against multiple medical provider defendants. They failed to appear in any way in this case. They have not filed a motion to vacate, and there is no right to an appeal of a default judgment under New York law. And that default.
But you could have done this without us too. I mean, I get that.
Yes, Your Honor. The appellants filed the appeal, so of course I needed to respond to it. I would not be opposed to a stipulation between the parties, certainly, given that the error is a narrow clerical
error. It's a little late now, isn't it? I think it may be a little late now, but we thank you.
Right.
Yes, Your Honor. And if there are no further questions, I will rely on our papers on this case. Thank you, Your Honors.
Thank you. All right, Mr. Landsberg, you have one last minute for rebuttal.
Right. I can mirror what Mr. Rothschild said. He and I have been acting in good relation with regards to this case and other matters. The only reason that I couldn't stipulate to that matter is because the order itself on a whole should never have been granted to begin with. It wasn't just, she said, without opposition. The court issued a decision prematurely. So the rest of the defendants, who I stand in the shoes of, the assignees, the assignors of my client's no-fault benefits, they didn't technically default. So it's not like they don't have a right to appeal here. There was never an order that should have been decided against them. And my opinion is that if their rights to default are granted against them, that could prejudice my client's rights to have his no-fault benefits extended if the facts are held against him on the merits. And that's the only reason I couldn't stipulate.
Fair enough. I understand that. Okay. All right. Thank you both.
Thank you for your time, Your Honor.
Thank you.
Okay, Shire versus Shire.
Good afternoon. David Kiko, may it please the court. David Kiko, Pillsbury, Winthrop, Shaw, Pittman, for Catherine Shire as the preliminary executrix of the estate of her late husband, Bob. The question on appeal is a straightforward one. It's the meaning of a document entitled Option Notice to Exercise to Henry Shire and Robert Shire, parent HR shareholders. It's at the record at 737 through 38. As well as an attachment thereto entitled Calculation, another two terms, used for the 2014 option. Specifically, the question is, did that document modify or amend a 57-page shareholder agreement, which is in the record at 209 through 65, to modify three different acts? One is how the estate shares were to be, the value of them was to be calculated. The second one was how options exercised after this option notice were to be calculated. And the third was how the 2014 option itself was to be valued. It's our position that the last point is presents issues of fact as Supreme Court ruled, but the first two are clear as a matter of law because the agreement is not ambiguous. It simply does not mention the other options or the estate shares. And as this court knows, and it's ruled multiple times, in order for an amendment or a document to be considered an amendment or a modification, it has to contain a clear and unmistakable and without ambiguity manifestation of intent to modify the earlier agreement. And I cite the court to Jacoby and Myers versus Crispo, this court's 1999 decision. Also, several other decisions, which I
Counselor, isn't it a fair argument to say that there are really issues of fact as to whether or not there was a amendment based on the notice?
Your Honor, in all due respect, I don't believe so. Again, very similar cases that we've cited have carefully read the document here in light of the fact that it doesn't mention at all the other options. It does, and it clearly mentions this option. It certainly doesn't mention the estate shares. Insofar as the estate shares are concerned, they're dealt with in a completely different section of the shareholders agreement, Section 6, whereas this notice, and it just says it's a notice, only mentions Section 10. Section 10 is the provision that deals with options. Furthermore, the attachment only says that it's the calculation for the 2014 option. I would submit under the standards and given the fact.
This is Judge Gish. Under the shareholder agreement or under the agreement, is the calculation for the value of the estate liquidation, the estate redemption, different than the sale of the options? What's the formula as originally stated?
There's a slightly different formula. They are both based on something called the corporate enterprise fair market value, which is a term defined in Section 1. Again, something else not mentioned specifically. That section is not mentioned in the notice. The contention is.
I guess the thing that I'm trying to ascertain. I know the estate redemption talks about fair market value of 100% of the stock. And the implication of that is that you can't take a minority discount. And essentially what happened on the 2014 is that the parties either agreed or they didn't agree to take a 35% minority discount. In terms of the option valuation, is there that 100% limitation of fair market value, or is it fair market value where when you're not considering the entire asset, you do take a minority discount for the actual shares of given that you're only purchasing a minority interest?
So, Your Honor, the other side agrees that this is a modification, that the option shares are to be valued, but for whatever this document means, at 100%. Interestingly, however, in the record, Christopher testified, this is Christopher Shire, testified at his deposition that he thought that the notice was consistent, even though it's now conceded it is not. And James, these are the co-CEOs of the company, just testified that he didn't believe the notice was an amendment of the stockholder agreement. But now on appeal, there's an agreement that, in fact, both call for 100%. And again, in the Jacoby and Myers case, this court found significant the fact that there was no mention of the specific provisions which was claimed to be modified by the document. Turning quickly to the 2015 through 17 exercises, the stockholder agreement in Section 10, although my opponent characterized it as being one option, in fact, it calls for 5 separate exercises. The fact that one exercise has been made doesn't obligate Xylaware to exercise any of the other options. Furthermore, the notice has to be given each and every year. So the fact that you give the notice at the beginning doesn't mean that you have given notice for the others. Finally, each option has to be separately valued at the time of the exercise. And so again, it's our contention that it's very clear that merely valuing the 2014 option as was done doesn't mean that you have somehow changed the formula for what else it was to follow. There's also a contention that insofar.
Your time is up, so I'll allow you to finish this point, and then we're going to hear from your adversary.
I will stop. I've pretty much finished, and I'll deal with the 2014 on my rebuttal time. Thank you, Your Honor.
Thank you. All right, Mr. Kennedy.
Thank you, Your Honors. James Kennedy for Xylaware. I think that Justice Gish put her finger on something that Mr. Kecko is glossing over. Let me read a statement from his brief. The valuation formulas for the option shares and estate shares both use the corporation's enterprise fair market value as one component. There is no difference in the method for valuing option shares and estate shares at all, other than the date of the evaluation. In each instance, the shareholders agreement provides that you begin with the corporate enterprise fair market value, and that determination is based on the earnings over the preceding 3 years. So what happened here was before there was any exercise of the option, at the recommendation of the accountant who Bob Shire had hired, who had worked for him and for Xylaware for years, Bob Shire said, look, in my professional judgment, this formula doesn't work. The formula provided for a share of a minority interest. Each of these transactions is a minority interest, and it doesn't work.
You mean in the formula in the shareholder agreement didn't work?
Correct. It's
Because
probably,
it didn't provide for a minority discount if you're valuing 100%. And we're talking about a minority share.
and the reason he recommended it was he said that Robert Shire and Henry Shire each took a minority discount 2 years earlier in filing gift tax returns on the same shares for the same corporation. And he said that
that may be true, and that sort of assumes that there's sort of an objective fact of what value is. On the other hand, you know, it's no secret that for gift tax purposes, you're really looking to kind of keep the value low to keep the taxes low. And so you'd want to apply that minority discount. But if your parties agreed to a different formula, doesn't that, even if that formula doesn't reflect value, it doesn't reflect the right value, don't we have to follow that?
Well, the issue is this. Before they implemented the option share purchase and estate share purchases, they agreed through the option notice to change the formula. And all of this—
That's something else. That's the issue that is
the issue in the
presented in this appeal.
That's correct. And that's the issue. And Justice Cohen said the evidence on 2014 is so powerful that it would be awfully difficult for the plaintiff to prevail in front of a jury, but he was going to let the jury consider it. He said, moreover, there's ample evidence from which a jury can infer that the agreement to add the discount to the formula, which is very explicitly laid out in the 2014 notice, signed by Robert Shire on behalf of Xylaware as the officer of the company, signed by Robert Shire on his own individual behalf, that was intended to work, reading the contract together with the subsequent, no parole evidence issue here, subsequent notice, that was intended to change the formula. And the reason that the accountant gave, whether someone agrees with him or disagrees with him, is tax return consistency. He said that Robert and Henry Shire could be upside down with the government, and this was consistent with advice that the attorneys had given Robert Shire.
That may be the reason. I mean, honestly, it sounds like good advice, quite frankly. If I didn't order it, then gift tax returns if you start messing around with the value.
Right. So the issue for this court is, number one, the plaintiff moving for summary judgment, when they completely changed their theory, said no option shares had ever been purchased. This court said, as a matter of law, because of tax estoppel, at least 21 option shares were purchased. They then considered 28 shares were purchased. All of this happened when the summary judgment motion was pending, and changing their entire theory. Now they say, well, the option shares were undervalued. And they can't go down that road because as to 2014, we think as a matter of law, we don't think the Judge Cohen went far enough. He said, look, there's clear evidence here of an intention.
Counselor, this is Judge Singh. Aren't there issues of fact with respect to Robert's capacity at the time of the 2014 option notice?
Well, Your Honor, that's a matter that really gets my blood boiling a little bit as a litigator, because
we're having trouble hearing you, Mr. Kennedy. Repeat the last sentence.
Mr. Kecko's predecessor counsel told Justice Cohen, we are not raising, plaintiff was not raising lack of capacity on summary judgment. Plaintiff believed she was entitled to summary judgment based on the papers alone, rendering the 2014 option notice irrelevant. And in fact, at the time, plaintiff had withheld documents going to Robert's capacity, and the judge said, I need to know if this is an issue on summary judgment, because if it is, then I'm going to give Xylaware the opportunity to redepose Mrs. Shire. They said no. He said, okay, so the preclusion order, he sanctioned them. And he said, for the preclusion order aspect of it, I can kick it down the road and see what happens on summary judgment. And that was not a statement that they are reserved the right not to put on any evidence. There's no evidence of lack of capacity in this record. The only evidence, and it was expressly waived as an issue. They said, we're not raising it. The only evidence is that Robert was normal at the time the option notice was signed, and that comes from his wife, Catherine. So the capacity issue is not only a red herring, it's a real procedural trap where a counsel gets up to avoid a preclusion order and tells a judge, we're not raising capacity, and then comes to the appellate court and says, oh, there's no capacity, so we have to have a trial. I look at this the following way, Your Honor. The question of whether or not they get summary judgment is a no-brainer. They don't, because the 2014 document, certainly as Justice Cohen found, has plenty of in it. It specifically references the fact that they're changing the way that they're calculating corporate enterprise fair market value, not to abide by the contract, but to apply what's called the Jennings discount. So they can't get summary judgment as to 2014, and even as to beyond, because as the court, as Justice Cohen found earlier, there are issues of waiver, and that wasn't raised again by them. It wasn't negated by them. So the real issue for this court is the following. Do we, one, give summary judgment to Xylaware on 2014? Because how can Robert Shire sign a notice saying we're using a discount, and here's the way it's applied, and here's the purchase price, sign it for himself and sign it for Xylaware, and then turn around and challenge that price? I think you've got to go further.
I'm going to ask you to wrap up.
Yes, summary judgment on 2014, but even further, the change was not just to the price. It was
That's
to
not
the
wrapping up. You more than exceeded your time. I'm sorry, sir, but we're really running short of time this afternoon. You have to be more cognizant, or maybe I do. Could be.
I was
Okay.
trying to respond to the court's questions. I appreciate the time, Your Honor. Thank you.
Understood. But we are familiar with the case. I mean, we're a hot bench. All right, Mr. Kiko, you got
Sure.
2 minutes, and I'm going to hold you to it.
Okay. First of all, the formulas are different. Mr. Kennedy misspoke. The formula for the state shares takes into account insurance, which is not included in the other formula. Furthermore, the issue about the fair market value of the estate, that term, if you look at the calculations, there's no explanation. In the actual calculations, there's no explanation as to how that was changed, if it ever was. Going now to the issue to Justice Singh's question, the argument that Mr. Kennedy makes is wholly baseless. This motion on discovery and sanctions occurred at the time that our side had filed for summary judgment, but the response hadn't been filed. There was no motion on the other side saying we were cross-moving for summary judgment. Rather, there was a request to search the record. The question was, does in fact your motion for summary judgment depend in any way on issue of Bob's capacity? The issue was, it does not. That is wholly correct. It's still the case. Insofar as the statement, there is no evidence in the record that Bob lacked capacity, that is wholly wrong. Bob was diagnosed in November
But presumably, had they actually moved for summary judgment, you would have responded with that.
Exactly correct.
Okay,
It's
so
in
we
the record
understand.
in any event.
We understand.
There are actually letters
We
and emails
understand.
where
Thank you.
it's acknowledged. I'm
Thank
sorry.
you.
Thank
Okay.
you, Your Honor.
Thank you. Okay, next case is DeManiel against DeManiel.
Good afternoon, Your Honors. My name is Jackie Veet. I represent the appellants, the cross petitioners, Christoph DeManiel, Taya Thurman, and Maxwell Snow. This is a very disturbing case of a brother in a wealthy family trying to abuse the Article 81 statute by trying to control assets of his sister, Adelaide, accomplished through false allegations against other family members, namely my clients, who happen to be the closest family members to Adelaide. And in this case, on this appeal, there's 3 issues that we ask the court to do. First, we ask that you reverse 2 orders that were put in place against our clients and on which all parties now consent. And the third thing is to determine whether, when this case goes back to the lower court on remand, a different justice should be appointed for the case. The 2 issues at order are a standing order in which our clients were deprived of their standing as
counsel, all parties agree that the appellants do not lack standing. Is that correct?
Now they do. On this appeal, the petitioner withdrew their objection that they had been pressing for a year. But yes, that's true. And Adelaide has always supported the appellant's position in this case and has wanted them to participate.
Okay, so that's one issue. The second issue?
Likewise, all parties agree that on the advocate witness order where the court disqualified my client's other counsel, Sheila Tendy, from representing them because petitioner's lawyer claimed that she might be a rebuttal witness. The petitioner has since likewise withdrawn opposition to that order, and so all parties consent.
So Counselor, why?
I'm sorry, go ahead.
So why should the case be reassigned?
Let's discuss that. There's several reasons. First of all, this, and most important, I think, this case is going to have to start over anyway. There has been a mistrial motion that was filed a year ago based on the several facts that that the petitioner's attorneys, Withers, were disqualified. They had been Adelaide's counsel for 40 years. They brought this case against her and carried on for 2 days of trial, or a day and a half of trial and the whole beginning of the case, and were against her before the court ultimately disqualified them. There were 2 pending disqualification motions at the time, but the court let them go ahead on the case against her. Secondly, she was deprived of her ability to have counsel because her counsel was disqualified, and she was given a court-appointed attorney who was given all of 3 days to prepare for a hearing that was very complicated and put up against.
What does that have to do with the ability of the judge to continue to hear the case?
Okay, let me explain that. Because this case is going to have to start over anyway, we believe the appellants and Adelaide deserve a clean slate when they go back. This judge predetermined factual issues in this case before Adelaide ever had a chance to put on a defense.
So what in the record supports your argument that the judge predetermined these issues?
Because she, even in the very first days of trial, she made decisions about putting a temporary personal guardian based on findings that hadn't even been asked for in the petition. There had barely been any record made. The case had barely begun. Our clients were precluded from participating, from calling witnesses, from cross-examining, and there had been an in-camera hearing that none of the attorneys have ever been at, which was to address whether the Schulte-Roth counsel who was defending her had been fairly and voluntarily hired.
I just want to clarify in terms of this record because we had limited orders in front of us. So the in-camera was with the AIP?
The in-camera was with the AIP.
And who else was there besides the judge and the AIP?
I don't know right now because there's no transcript of it. We were not allowed to be there. Maybe Adelaide's no transcript of it, and
not even a
there may be a transcript. I'm sorry, Your Honor. There may be a transcript, but we have never been allowed to see it, and I don't even believe Adelaide's attorneys have ever been allowed to see it. But Adelaide's attorneys are here, and so you can ask that question. So there was this in-camera hearing, which was supposed to be solely for determination of Schulte-Roth's ability to represent her in this case. And somehow the judge below came out of that hearing making factual determinations before the hearing had even started.
What did she do?
What
was her factual determination?
Finding that a temporary personal needs guardian was required, even when the case had barely begun and there had been no defense at all. It was just at the very beginning, on the very first day, when the conflicted counsel was bringing out evidence.
There wasn't any information brought forward by the court evaluator at that time?
There was a report by the court evaluator.
So usually in these cases, you could correct me if I'm wrong, but a lot of times in these cases, the court evaluator comes in the first time, gives a preliminary report, and the judges in these cases do start to kind of make temporary orders to kind of like get the case going. That doesn't mean that they predetermine the competency issue about whether a permanent guardian is needed for either the person or the property, does it?
In this case, the court evaluator never got on the stand, was never cross-examined by anybody.
Did the court evaluator submit a report?
We did not see it because we weren't part. She did submit a report to the court. I don't know if any of the parties saw it at that very beginning, but certainly we did.
Why would it not be proper for the judge to base her determination on that report that was submitted to her?
Well, I don't know that she did base it on the report as opposed to in the in-camera, because she kept referencing her own experience within the in-camera. So I don't know that it's true. I don't know what the judge rested on, but I know what she didn't rest it on. She didn't rest it on evidence in a hearing. There's supposed to be clear and convincing evidence of both incapacity and also a need for a guardian. This is an extremely wealthy woman with a full,
wait, stop. Whether she's wealthy or not wealthy, it's the same standard on Article 81s. All right.
Exactly.
And the court has a responsibility with respect to these, right? They're very sensitive cases, regardless of money. They're important cases. In these cases, there is a hearing of competency, but a lot of times in these cases, even before the final decision is made about whether a guardian is required, there are sometimes temporary orders put into place based upon the information that the court may have at hand, not an ultimate determination that otherwise allows the waters to be smooth so that the case can move forward. Why was this different than that? Tell me.
Well, first, I would submit that waters were not smooth here at all because we were precluded from participating right out of the bat. Adelaide was not allowed to have counsel.
The waters were supposed to be smooth for the AIP, not necessarily you, but okay.
Yeah, but we were, our clients were able to help Adelaide. They could help protect her from the false accusations. Their lawyer, who was disqualified.
Well, that goes to the issue of whether you have standing. And you did have standing, and you do have standing, and everybody agrees to that, right? And I can't see any reason why we as a court wouldn't otherwise reverse that. So yes, you're going to be able to show up and oppose the idea of George asking for a guardian. There's going to be a hearing on competency, and a final determination will be made.
Well,
so that the issue, and I understand. You got some rulings that bumped you along in a kind of difficult way. But the question really is something different when you say we want a whole new judge and you say the judge predetermined. And I think that's what my colleague Justice Weber was trying to get at. Other than the fact that you feel this was a bumpy ride and you got some rulings that you really think were wrong, and it sounds like the other side is going to concede that those rulings shouldn't stand. The question is more, what about the judge did, other than making bad rulings for you, that conveyed to you that she has already decided that no matter what you say, no matter what, she is going to decide against you. Go.
Yes, I would submit that the case law that we cited, that's not exactly the standard when this court has given a different justice. In fact, when there's even an appearance that there might not be fairness below, the court has at times changed the judge. And in this case, I would submit, yes, there were determinations that were when there was not evidence to support that there was procedural improprieties involving not just our clients, but Adelaide, and a rush throughout the transcripts to get done, as opposed to get to the facts, see if there's clear and convincing evidence. And the reason I mentioned her wealth is not that the standard is different, not at all, but she has all the lawyers, accountants, she has trusts in place, she has personal staff, she has tons of family who love her and support her. Her wealth makes it possible to have all the protections that she might ever want.
Those aren't legal protections, honestly, in lieu of a guardian. Maybe if there's a valid power of attorney and a healthcare proxy, you might avoid it, but just having. And it's nice that she has people who love her and care about her. But I don't know that would. But I don't know that would preclude the appointment of a guardian. But I get it.
Those are the issues I agree that will be addressed at the court below. And this will have to start again because the first days of trial, it seems necessarily there'll be a mistrial or we'll be right back here again.
But we don't have a determination about the mistrial motion yet.
Well, you don't. You have the facts support it, but that's true. The court will have to rule on that, and there was a stay in place, so the court has not ruled, and perhaps the court will rule that there's a mistrial. But I would submit that when a judge is in a case for a year and has a notions of the factual findings, it's extremely difficult for any human being to have a clean slate, to not think back on evidence that should not have been considered, that was got in camera, or information that was gained in a tainted trial by counsel of, again, a conflicted counsel, and that it'll be very difficult for anyone, me or the judge below, to erase that and start fresh. And this is an Article 81. This is a case where you're trying to deprive someone of their liberty, of their
aware.
Yes. So in this kind of a case, I would suggest you even need more careful. You have to be even more careful that these types of, that there is the fairness and the clean slate. And it's just very difficult for, I would say, this judge, any judge, me, anyone, to really start over in a fair way, given everything that has gone on so far. And I think that it would that's the basis for us asking for that relief.
Thank you.
Thank you, Your Honor.
Okay, Mr. Abramowitz. You're on mute. You're on mute.
Sorry. My name is Alfred Abramowitz. I represent the AIP in this matter. Let me get to the heart of the questions that you were asking, and it really reflects the problem and the catch-22 of Article 8110, where the fact finder, the ultimate fact finder, is also assigned the task of making a preliminary determination that an AIP is incapacitated to the extent of not being able to pick her own counsel. That happened in the ex parte proceeding that Ms. Veit mentioned. We do not know what occurred. We do know.
Is there a sealed transcript? I just want to know if there's a record of what happened there.
I am not aware of any transcript of that.
At all? Not a sealed one, even. Do you know who was with the AIP in the in-camera?
I do not.
Okay. All right.
I really don't. I don't know.
I believe you. Neither did Ms. Veit.
The record is not clear on that.
Do we know when it was held? When this occurred?
January of 2020. Yeah, we have the date it was held.
Okay.
And the determination of the court that the AIP was not qualified or did not have the capacity to pick her own counsel, and she disqualified the counsel of her choice. And then started the trial with the conflicted counsel, which she ultimately determined after a third of the trial was gone, that lawyer, the petitioner's lawyer, should not have been permitted to start the trial. All at the same time excluding Ms. Veit's clients that you heard about and which are the subject of the two orders that are to be reversed.
So they weren't allowed to even be in the courtroom while this was going on.
Correct. And the problem is when the judge assigned counsel to the AIP, she then rushed the continuation of the trial over the objection of the assigned counsel because she wasn't ready to proceed with the trial. So you have all of these errors occurring, but the fundamental problem that hits the problem that all of you raised on your questions of Ms. Veit is when a settlement was proposed and approved by the assigned counsel and approved by the petitioner, the judge said, I do not believe, I'm quoting now, I do not believe she has the capability to agree to this settlement.
A settlement for the proceedings, for everything?
Correct. Yes. And so when the judge says, I don't believe she's got the capacity to enter into this settlement, that is clear evidence on the record that she has determined that the AIP is incapacitated.
But again,
Yes.
this goes back to my other question. How do we not know that that was not based upon the report by the court evaluator?
Well, whether it was based on whatever it was based on, we have no opportunity to argue against it. The trial will be a sham if she's the ultimate fact finder, if the judge is the ultimate fact finder. And look, I want the record to be clear. Justice Rosado is a very capable judge, and she tried her best in a difficult situation with this trial during the COVID situation and everything else. This is not a personal attack. It's a fundamental problem where there has to be a preliminary finding of incapacity. There was a preliminary finding of incapacity, and then she then has to sit on the trial.
But that's not, yeah, that's not uncommon in an Article 81.
It's not
And so
uncommon.
would that result in a disqualification? I mean, it would be nice if we had judges who could try every aspect of this, but we don't.
In this case, it does, because she heard the trial and was tainted because of the lack of participation of the appellants, plus the fact that there was a conflicted attorney representing the petitioner, objected to right from the beginning. She was not permitted to let the assigned counsel have time to try to prepare her trial. And then when the parties agreed to a settlement with the assigned counsel, the judge determined that she doesn't have the capacity to enter into the settlement.
So do you agree with Ms. Viette that we need a new judge on this?
Yes,
I mean, that seems to be the only issue.
Yeah, right. I totally agree. I totally agree that that is the only issue, because the trial has to start over with a fact finder who is not tainted the way Justice Rosado has been forced to be under the circumstances. Again, I want to reiterate it's nothing personal against the judge. It's and COVID may have had something to do with this because of the delay. But the fact of the matter is that she has already determined, whether correctly or incorrectly, and we say incorrectly, and we will hope at a trial to demonstrate that she's not incapacitated. But Justice Rosado, through the actions that we've been describing, has determined that the AIP is in fact incapacitated. And so the trial would be a sham. It may look good and it may pretend to look good, but the judge has already made up her mind. And in those circumstances, we think, since the case has to go back and these orders need to be reversed, we think it only appropriate. And we're not saying that this happens in every case, but this is a unique case and it has a unique set of facts.
It happens in almost no cases. Okay, let's hear from Mr. Barber.
Good afternoon, Your Honors. Jeremy Barber on behalf of Respondent George DeManil. I'd like to briefly address the standing question, and then I'm happy to discuss the assignment issue.
Do you not also concede the standing question?
We do concede that the standing order needs to be reversed, but as a technical matter, I just wanted to point out that only one of the three appellants here, Max Snow, has actually filed a cross petition.
Right.
You don't need one. Why do you need one? If in fact they're claiming that you don't need a guardian because there's a power of attorney and healthcare proxy. I mean, that's a valid defense.
Well, Your Honor, there is case law that suggests that certainly they can bring a case to oppose the petition. There is no case that we have been able to find where that was accomplished outside of a petition, a cross petition, or the AIP. Let me briefly restate that. I have not found a single case that allowed somebody to be a party without either being the AIP, a petitioner, or cross petitioner.
Okay,
of course, they can seek to amend the cross petition and add.
But it was clear. So the question again, so the only question is whether you also believe that the case should be remanded to another judge.
I do, and I'd like to point out a number of things with regard to that point. First, I think it is absolutely unprecedented. I've not been able to find a single case where reassignment occurs in the midst of a guardianship proceeding, as we have.
In Ray Gordon, I think, is a case that we did.
Your Honor, Justice Weber, that case was reassigned to a case after a capacity decision had been made.
That is correct. That's
We've
correct.
also recently had a order to show cause hearing. That decision is pending by the court. It would do violence to this case, given the lengthy experience that Justice Rosado has to reassign it to someone else.
But your adversaries do note that you're going to have to start all over again. There will have to be, the proceedings are going to basically have to start all over again. And I actually thought of your argument that, she is familiar, Judge Rosado's familiar, with the facts, the parties, et cetera. And so perhaps to some extent for judicial economy, it would make sense to remand it back to her, unless, again, there can be a showing that somehow she has prejudged the outcome.
Well, so, Your Honor, I think there is judicial economies. I think there is a pending order to show cause before Justice Rosado at this time. But with regard to the issue of predetermination, I think my colleagues are wrong for 3 reasons that Justice Rosado has predetermined things. First, there's absolutely no evidence that what occurred in the in-camera 8110 proceeding was anything other than proper. If you look to—
How do we know if we don't have the transcript, even a sealed transcript that comes to us? Usually in cameras, that's what we get.
Well, certainly the burden would be on my colleagues to suggest that something improper happened. There should be
nobody knows. You don't know what you don't know. But, somebody could have provided a sealed in-camera transcript. If there was no transcript, then that's a problem. You'd have to concede that.
Your Honor,
Can you shed any light on those proceedings? Were you present, or do you know who was present?
I do know that at record 308, there was an order appointing Rachel Shamalov to be counsel for Ms. Deminil at the 8110 hearing, which occurred a month later. I do not know whether there was a transcript. I have no reason to think there wasn't a transcript. I don't know whether Mr. Abramowitz, as Ms. Deminil's current counsel, has sought that transcript. I can't answer the question as to whether there was a transcript. What I will say is, it is, as your honors have pointed out, it is utterly normal in these cases for judges to hear the 8110 proceeding and then go on to determine competency. In fact, mental health—
Counselor, this is Judge Singh. Can you respond to Mr. Abramowitz's point that that the judge below essentially has made a decision regarding capacity by rejecting the settlement? That is a concern. No?
Yes, and I'd like to address that in 2 parts. First, I want to point out that the mental health law, Article 81, specifically contemplates that judges are required to observe the AIP in presence so they can obtain their own impressions. That is what Justice Rosado has done here. In the course of the 8110 proceeding, she has obtained her own impressions of competency, and that is expected in these types of cases. It may be different in criminal cases.
You can't base a guardianship based on your own impressions.
That's for that, and I think the record is replete.
Can I ask you a question? Oh, I'm sorry. Finish answering Judge Singh's question, and then I'll ask you my question.
I would point your honors to there's numerous evidence in the record that Justice Rosado was not relying solely on her own impressions, but was in fact planning to hold petitioner to his burden. I would point your honor to record page 386, where she says, and I quote, "It's up to petitioner's counsel to make his case." She, earlier in the record, at record 346 to 47, she says, I would like to hear from witnesses, so I have some independent information besides my own observation in the court evaluator's report. This judge has not predetermined the issue. If you look throughout records 332 to 334, you'll see time after time, she says, I want to hear from witnesses. I want to hear the evidence. It is not the case that she has predetermined anything. And so I think that is, as a matter of fact, incorrect.
Then why reject the settlement? I mean, there's a global settlement, right? Is that correct? First of all, there's a global settlement among the parties?
There was a presentation over lunch during the first day of the guardianship proceeding of a potential settlement, and the settlement was not accepted.
By the court.
By who? By the court.
Yes.
Okay. Yeah.
And on the grounds as stated, that she didn't believe she had the capacity to enter into a settlement.
Your honors, I would point out the mistrial motion that my counsels refer to, of course, is pending. That will be resolved in the normal course below.
Is there a court evaluator's report?
There's been 3 court evaluators report in this case.
And you've had access to it?
Yes, all parties have.
And the other parties, the other people who were not allowed to be parties have not.
No, they have actually, Your Honor. There was a hearing on an order to show cause.
Was there was there a court evaluator's report before the court put in place a temporary guardianship?
There, I believe so, Your Honor. There was an initial court evaluator. I want to be clear. There was an initial court evaluator's report before the 8110 hearing, which happened on January 10th. The first day of the hearing was January 16th, and there had been a court evaluator report before that. There was testimony, and it was after that that the temporary guardian was expanded to cover her person as well as her property.
There was an expansion. There was a temporary guardian put in beforehand.
Correct. And Your Honor, I believe Mr. Finkelstein was appointed as a temporary guardian on December 27th, and I believe that was before any of the court evaluator reports.
That was only for assets, not for a person. That was only for assets.
We're not having a conversation here, folks. Honestly.
I'm sorry.
No, really, you should be sorry. This is a court. All right. All right. Anything else, Mr. Barber?
Nothing else for me, Your Honor, other than we would oppose the efforts to reassign this matter, given the pendency and the fact that it's a live, active matter. We think that's an extreme remedy, which is not appropriate in this case. Lack of determination.
Ms. Miette, you have 2 minutes.
Thank you, Your Honor.
2 minutes, please.
Yes, I will be quick. On the standing question, just quickly, the Azzi case is right on point. It's in our brief. It's one family member representing others as cross petitioners. It's clear that we should have had standing and always did. Secondly, we sought that hearing transcript that you're talking about, that January 10th. We asked for it in the Article 78 proceeding when we asked for all the transcript. We've been asking for that forever, and it has never been provided. And I don't know if it exists or not, but we have been asking for a year for that transcript. The Gordon case, yes, it was after a guardianship determination, but I would say that's not a distinction that matters here. Given this record, the finding of this judge about capacity already, even on the very first day of trial, and compared to Gordon, which was really the same thing, where the cross petitioners were not allowed to participate and the court had predetermined issues. In that case, capacity was everyone agreed on that there was no capacity, and the only issue was whether there should be a guardian, and they were not allowed to be heard on that, and she decided that issue. In terms of rejecting the settlement, to be clear, everybody agreed on that settlement. The court evaluator agreed on it. The court appointed counsel for Adelaide agreed on it. Sheila Tendy for my clients agreed on it. It was reached in the hallway by every single constituent. It was brought to the judge first to be signed off during the first day of right before the hearing was to start, and as has been heard, the court refused on grounds that she did not have the capacity to agree to it. So that is what happened with that settlement. And I'm sorry, I apologize for jumping in before, but the temporary guardian was appointed in December solely as an asset guardian. The petition didn't ask for any personal guardian. Nothing was put in place. It was all about assets. And then at the very first day of hearing on January 16th, the court sua sponte extended Mr. Finkelstein's role to include some aspects of personal needs guardian for the first time. Yes.
All right. Thank you.
Thank you very much.
All.
Thank you. Thank you very much.
Thank you.
Okay, McCormick family against Interactive and Fidelity.
Yes, Your Honors. Good afternoon. Thanks for bearing with us this late in the day. Any event, I hope that your attention stays for this case. I think it's important still.
Every case is important, sir.
Yes, I completely agree. We are here, Your Honors, because we believe that the trial court unfortunately erred in two substantial respects in granting a 3211 motion below. And I will tell Your Honors that even though there are 93 pages, as I count them, of briefing in opposition to our appeal, neither of appellees are arguing that the two errors that I'm referring to were correct. It's in fact not disputed. So let me tell you the first error. This is all, by the way, under the debtor and creditor law of this state prior to its amendment in 2020. So I'm talking about the law as it existed up until the most recent amendments. We brought first a series of claims for actual fraudulent conveyance actual fraudulent conveyance claims under debtor-creditor law 276 and 276A. The judge below correctly stated, he began by correctly stating that only the intent of the transferor is important with regard to actual fraudulent intent. And that's correct.
Counselor, this is Judge Singh. Putting aside that issue, putting aside the issue that you want to go into just now, could you explain to me how have plaintiffs shown that the defendants have dominion and control over the assets in this case?
Okay, this is not an issue. This is not either of the two key errors that we are talking about, just so Your Honor is aware. And the judge did not discuss this, as I'm sure.
Well, this is the issue I'm interested in knowing about.
That's quite all right. So let me pass to it. The five most recent judges in this state, district court judges, Judge Buchwald, a bankruptcy judge in Manhattan Investment, and a panel of 3 appellate court judges by the Second Circuit have all ruled on the issue of dominion control and have held in a series of cases related to Manhattan Investment that banks in a situation such as this have dominion control. And actually, just to start, Justice Singh, Judge Singh, it is not disputed at all with about $3 million of this claim, insofar as those were commissions and fees that were taken by Interactive and Fidelity. It's been pleaded and alleged in our complaint on our 3211, has to be taken as true. We've alleged that 1.3 million give take was taken by Interactive and about 1.5 was taken by Fidelity.
Now these commissions, Counselor, these commissions presumably are pursuant to agreements that certain commissions are earned, correct?
Quite so. It doesn't matter that it's illegally taken. It just matters that they had dominion and control over it. And both Fidelity and Interactive.
In other words, you're saying that they could go into the account and take as much money out of the account as they want.
No, Your Honor, that's not what I'm saying. What I'm saying is, Your Honor wants to talk about dominion and control. Dominion and control is defined by the ability of a party to take money, to take the corpus of the funds.
And the monies presumably are being taken because those monies are earned commissions, correct?
Precisely. But if they are taken, then they are within the dominion and control. You're talking about whether it was legally done, which is, by the way, not a defense to fraudulent conveyance claims if they took them without good faith. But you're just talking, so it doesn't matter whether it was taken pursuant to agreement. When they took it, they have dominion and control over it. And both Fidelity and Interactive concede the point. They both say in their briefs, we don't argue to the contrary about commissions. What Fidelity says about commissions is, well, you didn't argue about commissions in your complaint, which is incorrect, because the commissions were part of the $38 million of money that Andrew Kasperson put into Fidelity. And Interactive concedes it and just says, we concede that there's dominion control for those funds. And they really have no issue other than to concede it. And that alone, Your Honor, that alone should warrant a reversal and sending back to the trial court for further factual discovery, because the other issue that Your Honor may be interested in, the remaining $35 million or so of the funds that are at issue here, the question is a factual question. In other words, what were the facts? Did Interactive or Fidelity have control over these monies, or didn't they? We can hypothesize and postulate about agreements all we like, but this is a 3211 motion, not a 3212. And to determine facts, factually how much they decided to control this money, or factually how much they didn't decide to control the money, that's decided in discovery and on a 3212, which this is not. We were deprived of the ability to put forward facts. On the basis of the facts that were very carefully alleged and pleaded in detail, Your Honor, we do indicate, just as it was true in Manhattan Investment, both Interactive and Fidelity had dominion control over these funds because they could invade these funds at any time to satisfy themselves for margin calls, which was, of course, in fact, the case, because as we explained, Andrew Kasperson was trading weekly put options on the S&P 500. He was always putting them down. It's like betting on a heads or tails coin that it's always going to come up tails. You're bound to lose, And when that happened, per the agreements that Interactive and Fidelity have, they had every right to go in and take all of the money. Now, did they? Didn't they? I will tell Your Honor, that's a very interesting discussion that we might have academically, but it's really not appropriate. It's premature. And that's because this is, as I said, a 3211 motion. And that's on dominion and control. And in fact, I will tell you further, while that's what the appellees argue. They don't argue about the trial court's two significant errors that should warrant reversal. They don't fight that at all. They argue dominion and control. I will tell you, Your Honor, while they marshal a vast number of cases, two things about those cases. Number one, if you read them,
All right.
they are all,
Kagan,
almost all.
Your time just ran out, so I'm going to ask you, I'm going to urge
I'll
you.
just wrap up. I'll just say very quickly two things. All those cases, virtually all of them, are summary judgment cases, not 3211 cases. And second, almost every single one was considered and rejected by Judge Buchwald in Manhattan Investment and by the Second Circuit.
Thank you. Thank you. All right, we'll hear from Gary Minute first.
Your Honor, Mr. Tabak and I agreed that he would.
That's fine. I'll accept that agreement. Mr. Tabak, you have 3 minutes. Go ahead.
Thank you, Your Honor. Yeah, I think Justice Singh, you hit the nail on the head. This case can be resolved as to fidelity entirely on the dominion and control issue. It's a question.
But what about your adversary's point that taking commissions could be dominion and control?
He is correct. However, the complaint does not allege any commissions in the relevant time period as to fidelity. Paragraph 83 talks about commissions from 2012. The fraud here started in 2014. CPLR 3013 requires that pleadings be sufficiently particular as to the transactions at issue. Here, the complaint is quite particular. As to fidelity, it defines the only transfers it's attacking as transfers into Casperson's account. And each cause of action against fidelity goes after only these defined fidelity transfers and not commissions paid out of the account. It's a separate transfer. I think appellants have tried to get around this issue below, and they're trying to do it here and say, just please don't decide this, send it back with this really big claim and trying to leverage for settlement. But it's a strategic choice that they made. And let me remind the court, both fidelity and the court below highlighted that the only allegations against fidelity related to the deposits into the account, not the commissions. We went over this at the argument. Appellants chose not to seek leave to amend their complaint to add commission claims against fidelity. They made the strategic choice to try to keep their deposit claims alive by pretending that the complaint also had commission claims. So there's no reason for this court to fix the strategic decision that they made. They have to live with that. Even if they could allege commission claims or had done so, they wouldn't survive because of the actual fraudulent conveyance claims. There's no intent alleged, and there's no good faith, lack of good faith alleged as to the constructive fraudulent conveyance claims. Appellants rely on Casperson's fraud in getting money from his relatives, but that's a different transfer than his transfers into the account, the deposits, which is even further removed from the commissions. You can't take intent and move it 2 transfers ahead. So for those reasons, we respectfully ask that you affirm the decision below.
Thank you. All right, Mr. Minute.
Thank you. I'll pick up with the question that Justice Singh asked about dominion and control. And no dominion and control is really another way of saying that there was no transfer. And if you look at the transfers from Mr. Casperson to Interactive Brokers, it was basically the $9.5 million that was left after he had finished trading through Fidelity, and he moved that money with the exception of a very small additional amount of $30,000. Almost all the money came from Fidelity and went to Interactive Brokers in the name of Mr. Casperson. And so there was no transfer. The creditors of Mr. Casperson were in exactly the same position before that transfer was made and after that transfer was made. Any debt that they were owed by Mr. Casperson was not made more difficult to collect by that transfer. And that's another way of looking at the dominion control issue. But Justice Singh, you is correct that with respect to the commissions, that defense does not apply because the commissions are paid to the broker dealers. But Justice Singh, in your question, you asked the correct question, aren't those earned commissions? And the answer is yes, they are earned commissions. And because they are standard earned commissions, and there's no allegation that there's anything inflated or improper about those commissions. In other words, they're standard commissions that anyone would have paid who would open that account. And the plaintiff has attached both of the broker-dealer standard account opening documentation to his complaint. Those claims fail for that independent reason. So everything except for the commission claims fails based on dominion and control. With respect to the commissions, those claims fail because those are earned payments. It's the same reason when you have a fraudster who is using Federal Express, for example, to send out Federal Express statements, the Federal Express bill can't be avoided. You can't get back from Federal Express the money that they were paid by the fraudster because they earned that money. There's nothing improper about that payment. And it's exactly the same thing here. With respect to the Manhattan Investment Fund case and the Bayou or Goldman Sachs case that Mr. Kagan referenced, those cases are extremely different than this case. First of all, the Goldman Sachs case, the Bayou Fund case, they were both Ponzi schemes. In the Bayou Fund case, all the Second Circuit was doing was saying that the arbitration that had heard the claim against Goldman Sachs did not act in manifest disregard of the law. So a totally, different standard. And
the other case, I'm going to let you finish up because you're over your time.
Okay. And in the Manhattan Investment Fund case, what happened was that Bear Stearns got wind that there was a fraud going on or something improper going on with respect to the fund, and they required the fund to set up an account that they had extensive controls over, and essentially they used that fund to pay themselves to reduce their exposure to the fraudster. That has absolutely no application here. And just finally, could I make one sentence on Justice Sherwood's?
Say one sentence, but you're way over your time.
I'll try to do one sentence. With respect to Justice Sherwood's error on the actual fraudulent conveyance claim, we agree that he came to the correct result. All we're saying is that there was an additional reason that he should have held in our favor, and he got that one piece of it wrong.
Okay, thank you. All right, Mr. Kagan, 2 minutes. You're on mute.
Sorry, I just want to make 3 points in response that I think should clearly indicate that reversal is warranted here. First, Fidelity indicates that we didn't plead commissions. We're not pleading fraud, and the fraud rules of particularity don't apply here. This is simple notice pleading. We alleged in the complaint at paragraphs 168, 176, 182, and 42 issues about commissions. That's what we're talking about now. It's plain.
So I want to understand your argument. So essentially, commissions that are taken in the ordinary course of business pursuant to various agreements, you're saying that's sufficient dominion control for the purposes?
It's sufficient for dominion and control. It might be immune from debtor and creditor law. This is a different concept because it was taken with good faith, which is what Mr. Mennett was not discussing because he ignores the good faith requirement of debtor creditor law 272. It doesn't matter if it was earned, if it wasn't taken with good faith. That's a requirement written right into 272A and B of the statute, which Mr. Mennett and Interactive ignore. We allege in detail that Interactive did not take in good faith. If they did not take in good faith, and again, this is 3211, remember, not summary judgment. You must assume what we said is true, and it's alleged in detail. If they took without good faith, it doesn't matter if it was earned, it's still fraudulent and must be set aside. That's the law in the state of New York and in all of the district court cases that have reviewed this issue under the DCL. Interactive ignores good faith. That was my second point. The final point that I want to make, also with regard to interactive, is they try to distinguish Manhattan Investment, and I heard Mr. Bennett say it's a totally different case. That was a Ponzi case. This too is a Ponzi case. We allege it in complaint paragraph 12, and you don't have to trust just us. Judge Rakoff in the Southern District stated on the record in an allocution that it's a Ponzi-like case because Andrew Casperson was stealing from the current investors to pay off the past. And he was doing it by guaranteeing a continued rate of investment, just like any other Ponzi. To the extent that your honors might wish to quibble with us, that's a question for discovery. But what should not be a question for this court is we've alleged more, I would respectfully submit, more than is required at the stage of a 3211 motion.
Okay, thank you. Thank you all.
Thank you all.
Thank you for your patience
you.
and waiting. All right, finally, Mr. Budlowitz.
It's, Your Honor, it's Budwilowicz.
Budwilowicz, thank you. Go ahead.
I'll be brief and fast. I'll start with the prior proceedings. Appeal entered around October 11 to 19, and 564 granted on March 10 to 20, and 2752 on October 2 20, and the appeal was perfected right thereafter or around that time. The nature of the proceeding is breach of contract, tort, and also criminal aspect. The object of the proceeding is agreement and physical damage sustained during 15 years employment of the appellant. Important orders are the one dated 8/6/19. The defendant is in default and the answer of the defendant is stricken. And then the order appealed from 10/10/2019. The standards applied are principles of extraordinary circumstances and the Ross factor, fairness, truth, and judicial efficiency. Now, getting back to the arguments, I've numbered them. Argument 1, the jurisdiction of the Court of Appeals as defined in New York Article number 6, paragraph 3A is a so-called exception and is therefore not limited. The appellant moves to expand the original records with exhibits 1, 2, and 3, and these are referred to in the motion related to the grant order M564, I mentioned that before, and they have been reviewed and authenticated. There's a reasonable excuse and there are extenuating circumstances for failing to comply with the order dated August 6 to 19. Here's the focus on the appellant's conduct. And then the next argument is the 8th Amendment had been violated. Here's the focus on the appellant's status and condition, and more specifically, the non-compliance with the virtually inseparable consequence of his status and conditions. And I mentioned here Jones 444, F3D at 1136 and 1137. That's not mentioned in the brief. Appellant moves to restore the default judgment, return date February 14 to 19, because the answer of the was stricken. And then I come to the end. There's an amount the respondent owed around $800,616. The cost of disbursements, together with any other relief, the court found to be just and proper. And finally, the respondent offered a false instrument of filing in the second degree and violated the penal law, and more details are in the brief. And I'd like to mention it. It's in the brief, and I would like to thank the court, and I believe I used all my 3 minutes. Thank you very much for your time.
Thank you, sir. Have a good evening.
Thank you.
The session of the Appellate Division is now closed.
Thank you.